The city is presenting its direct case. Is the city ready to go forward with your next witness?
We are ready to proceed.
Yes.
City calls Chief Charles Hood.
You can come right up here, sir. Good morning. And would you raise your right hand, please? Do you swear or affirm your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Thank you. It's your witness.
Morning, Chief. Could you introduce yourself?
Good morning, sir. My name is Charles Hood, Fire Chief of the City of San Antonio.
Chief, how long have you held the position as Chief of SAFD?
April 16th, 2007.
Before taking that position, can you give us a background in terms of your firefighting experience?
Yes, sir. I was employed by the City of Phoenix in 1984. Rose to the ranks, held every position, left the City of Phoenix as an assistant chief, which is the number 2 position, to take this job here in San Antonio.
And what was your education before beginning that role?
Education?
Educational background.
High school, junior college, when I arrived here, and I've done work since I've been here also.
And you said you started with San Antonio Fire Department in 2007?
Yes, sir, April 16th.
And what were your duties when you started?
My duties when I started are basically the same duties that I have now. Obviously, the amount of personnel and budget have increased, but I'm responsible for the fire suppression, emergency management, fire prevention, emergency operations center for the city of San Antonio. And I'm responsible at this time for a little under 2,000 uniform and civilian. We have a budget of about $330 million at this time.
And is the disciplinary process part of your duties and responsibility?
Yes, sir, it is.
Can you give us a general idea of your role in the discipline process for SAFD?
I believe a lot of the discipline that happens in the fire service or in any business should always start at the lowest level between those supervisors and things like that. But my role is to make sure that the final discipline or the final outcome is my responsibility.
Are you the final decision maker on behalf of SBSD for discipline?
Yes, sir, I am.
Now, we're here today discussing the DWI incident and the evasion of arrest by Mr. Cerda back in on February 24, 2019. Are you familiar with that incident?
Yes, sir, I am.
Are you familiar with the DWI policy that applied in this case, the one that you updated in December, or actually December 9, 2014?
Yes, sir.
Was that the policy that applied to this incident with Mr. Cerda?
Yes, sir, it is.
I'd like to refer you to that policy, and that is Exhibit 17, the COSA Exhibit 17 in front of you. There are 2 binders, one for Mr. Cerda and one for the city.
Says 17.
17, yes. And it should start at the bottom with COSA 0064.
Yes, sir.
What was the reason for your implementing this policy on December 9, 2014?
We had numerous DWIs and several repeat offenders, firefighters, paramedics that had gotten more than one DWI. And so I think about this time, we probably had around 19 in a year. And so it was obvious that we had to do something else to make sure that we're protecting our citizens and protecting our employees.
And who was this policy given to?
This policy was given to all of our uniform members.
If I could refer you to the third full paragraph on that first page of COSA 0064. You can
Yes,
look
sir.
at that with me. That paragraph starts that this memo shall serve as notice to all uniformed personnel that effective immediately, the first offense of driving while intoxicated will result in an indefinite suspension. Did you see that, what I just read?
Yes, sir.
What did that mean to you when you issued that?
Basically that any of our personnel that received a DWI, they were going to be indefinitely suspended.
And then that paragraph goes on to state in the second sentence, based upon circumstances surrounding the arrest, a release and settlement agreement may be offered to the employee. Do you see that sentence?
Yes, sir.
And I didn't read the entire sentence. What did you mean by based upon circumstances surrounding the arrest?
There's a lot of things that can happen when someone's pulled over for a DWI. And so things that may be a circumstance that surrounds the event could be an automobile accident that they actually injured someone, injured property. They were uncooperative to law enforcement or civilians. So there could be a lot of different dynamics that surround that arrest. I hate to say a common, ordinary type arrest, but again, the arrest where someone is taken into custody, there's no other circumstances that surrounded the arrest of the person.
Okay, and you intended circumstances surrounding the arrest, did you intend that to have its common everyday meaning of those words?
Yes, sir.
And looking at the Merriam-Webster dictionary, circumstances is defined as a condition, fact, or event accompanying, conditioning, or determining another. Is that what you meant by circumstances?
Absolutely.
So it could be essentially facts related to the incident.
Absolutely. So again, if there was an injury, loss of life, major damage, things like that.
Getting to the Cerda incident, how did you first learn of Mr. Cerda's DWI incident?
I don't really remember whether it was through a phone call from my staff or I don't remember how I got the initial call on it.
Is it when a DWI happens, or is it something you find out about pretty quickly?
It depends. Sometimes we get DWIs that are in another county, and it may take a while. If it's in the city or if it's in Bear County, sometimes I'll get those calls at 6 a.m. from the sheriff, 5 a.m. from the police chief, or sometimes my staff. So it really kind of depends on where it is, what time it happens.
Okay. I'd like to refer you to, well, before we get into that, with the exhibit you have before you, that DWI policy, Exhibit 17, just to be clear on that, the first sentence says what will happen when a DWI occurs, correct?
Yes.
The second sentence, as far as the release and settlement agreement, is that, I see the word may in that sentence.
Yes, sir.
What does that mean to you?
So may to me ties back into the circumstances.
So that's optional
Yes,
depending
sir.
on the circumstances?
Yes,
Now, you had, when you have your disciplinary process with an incident such as this, you have, I assume, different facts and various information depending on the incident.
yes, depending on the incident and where it happened at.
And in this case, I'd like to refer you to Exhibit 3, the Selma Police Report.
Is that in the same book?
Same book, yes, COSA Exhibit 3.
Yes, sir.
And it's quite a few pages. It starts at 0583, goes into 0596. But the first page, do you see the name of the officer there, Officer Rodriguez?
Yes, sir.
Is this one of the documents that you reviewed in the discipline of this case for Mr. Cerda?
Yes, sir.
Did you see the offenses listed on the first page of the Selma Police Department report?
Yes, sir.
And what were those that were listed and reported?
Evading arrest, unlawful carry of weapon, driving while intoxicated, and impounded vehicle.
And if you could move forward to same exhibit, but page 586 at the bottom. Actually, 585 and 586.
Yes, sir.
These are part of the police report as reported by Officer Rodriguez. Did you also have an opportunity to review that at the time when this occurred 2 years ago?
Yes, sir.
On 586, did you see the supplement and the kind of the summary given by Officer Rodriguez of the events that occurred that night?
Yes, sir.
And those events were Mr. Cerda, of course. You saw those?
Yes, sir.
Okay. Along with the police report, did you have the, let me refer you to Exhibit 7. And Exhibit 7 is the Texas Department of Public Safety blood alcohol content analysis. And on COSA 0443, it's a third page of Exhibit 7, if you could get to that page and let me know when you're there.
443?
Yes.
Yes, sir.
Do you see where it has the description of the blood analysis from Albert Vasquez Cerda of 0.131 of grams of alcohol? Do you see that?
Yes, sir. The font is very tiny. I do.
Is this something you also had at the time of your review of this incident?
Yes, sir.
And also, if you could refer to Exhibit 6, this is the discharge summary when Mr. Cerda was taken to Bexar County Jail and was evaluated before that at Northeast Methodist Hospital.
Yes, sir. I see it.
And was this one of the documents you also had as part of your review of this case?
Yes, sir. That's correct.
And did you take into account the discharge instructions, diagnosis of alcohol intoxication?
Yes, sir.
And did you also take into account that he was medically cleared for incarceration as shown further down on that page?
Yes, sir.
Now, as part of did you also have a video which has been marked Exhibit 4? We're not going to show it again, but it's been played in this proceeding. There was a video of the incident, the dash cam from Officer Rodriguez and Mr. Cerda leaving the scene. And did you see that video?
Yes, sir, I did.
And you saw that at the time or before deciding on the discipline in this case?
Yes, sir, we saw that before.
Did anything stand out to you about that video?
You know, first of all, it's like we did have a video, which is sometimes we don't in situations. The troubling thing was it was a slow speed chase. It appeared that he was evading arrest and pulling a trailer. I witnessed him make a hard right on a intersection. Easily could have been people in that crosswalk. From what I remember from the video, there were people in the intersection, or not vehicles in the intersection. Remember him to continue to drive and then make a U-turn into what appeared to be an apartment complex and kind of jackknifed his trailer and was able to steer it back out into traffic. And then finally, when he was stopped, there was a felony type arrest on him, or a felony stop, to where they had guns drawn. So out of all the disciplines we've had, we've never had a DWI, someone tried to evade, which turned into a chase. And we've never had a DWI where they've actually drawn guns on them. So, you know, these were the big differences in the video that I saw, things that we just hadn't experienced before.
So were those factors you just mentioned, were those facts that were unique to Mr. Cerda's case?
Absolutely.
Now, you also, well, before you meet with Mr. Cerda to hear his side of the story, you send out a notice of proposed indefinite suspension, as you
Yes,
did in this
sir.
case. And let me refer you to Exhibit 2. Now that's Exhibit 2 is that's the notice of proposed indefinite suspension, and that's dated May 13, 2019, correct?
Correct.
Now, it looks like it bears your signature, is that correct? On the second to last page?
Yes, sir.
And also is that given to Mr. Cerda?
Yes, sir.
Now, upon receiving that, and that states kind of the general allegations and facts, what happens next after that point?
So what happens, we schedule a meeting to meet with the employee, or at this time, Mr. Cerda, and given an opportunity to basically speak to him. We spent time initially learning about their past, getting a Reader's Digest version of who that person is, their work history, when they came on, a lot of things like that. Prior to actually getting into the description of the incident. And that's an opportunity for them to give me more information or pertinent information about this case.
Now, before meeting with him, in this notice, Exhibit 2 that I referred you to, you also state in here the rules that were violated by Mr. Cerda. And in this instance, they include 2.02, abide by laws and departmental orders, 3.01, conduct and behavior, 4.07, negative public image, excuse me, and 4.09, use of intoxicants. Were those the rule
Yes,
violations?
sir.
Now, prior to meeting with Mr. Cerda, I guess, as you mentioned, you don't always have a video, but in this case, you had an actual video that depicts what happened. In your meeting with Mr. Cerda, besides learning about his background and in his version, did he give you any new information that would change your mind about the discipline?
No, sir, he did not.
Did he give you specifically any new information that he could recall about the facts and circumstances surrounding the arrest during your meeting with him?
Not really. He mentioned that his brother-in-law was in the vehicle, something to that effect. And and he talked about his day working, doing some work, I think at his mom's, and had a long day, and then was going to go look at some wheels with his brother-in-law or something like that. But that was the only information that we had that was different from what we had ascertained from the police records or things like that.
In the video and police report, there was nothing indicating his brother was in the vehicle, was there?
No, sir.
In the, after that meeting then, you then issue a notice of indefinite suspension, and I'll refer you to Exhibit 1 for that. If you could look at that for me.
Yes, sir.
When did you issue the notice of indefinite suspension?
May 22nd, 2019.
And that was issued under the policy of
2014.
Okay. Now, what happens when you initiate, or when you send out this notice of indefinite suspension?
As far as?
Well, does Mr. Cerda receive a copy?
Yes, sir.
Okay. And then he has the right to appeal that decision?
Yes, sir.
Okay.
He
We're
does.
here for that today.
Absolutely.
Has anything learned since that time changed your mind about any of the rules violated in the indefinite suspension?
No, sir.
Do you believe you were fair and just in issuing this discipline for the indefinite suspension for Mr. Cerda?
Yes, sir, I do.
Now, there were, during the time frame in which this policy applied, there may have been other DWI incidents of other employees.
Yes, sir.
Were there any DW-related disciplines of another employee under this policy in which the misconduct was of a comparable seriousness?
Yes, sir.
And what happened in those incidents?
They were terminated also.
Pass the witness.
Cross-examination?
I need your microphone, please. If you'll pull it. Thank you.
Chief, did you bring your notes from the meeting that you had with Albert Cerda when he met with you to discuss his indefinite suspension?
No, sir. Sorry.
Okay, so I asked if you brought your notes and your answer was no, that you did not?
No, sir.
For the record, those were produced several months ago to Mr. Fuentes in discovery when we gave him numerous documents, those notes from the meeting.
Did you review them before today?
No, I have not seen those notes, sir. As far as the documented notes, no, I have not seen them.
Who was in the meeting that took the notes?
Deputy Chief Meade,
And have you ever known him to take inaccurate notes?
not to my knowledge.
Okay, and are you telling me that you've never seen Meade's notes about Cerda before today?
I did not, sorry. I did not see the notes after Cerda, no. The notes that he documented, no, sir, I did not.
Okay. These were produced to us as COSA 0045. I don't believe, have we produced these?
They were not an exhibit designated by either party in this case.
Okay, may I approach the witness?
Yes. Before you approach the witness, let Mr. Urbis see what you're going to present to him.
Just so we're clear, the notes have other handwritten and highlighted portions that were not part of the documents produced. They're not the same set.
All right, you can make that clear on cross-examination. I'll allow him to present those to the witness.
Okay, Chief, what I'd like for you to do is to review just the typed portion of those notes.
The typed portion?
Yeah.
Okay.
And when you've had a chance to review the typed portions, please let me know that you finished, okay?
Yes, sir.
May we have a copy of those notes as well, please?
Do we have copies of them?
Mr. Urbis, do you have a copy of the notes that, as they were presented to the witness?
We have a clean copy. It looks like the witness was given a marked up copy that we did not produce. It's
I'm going to exchange a clean one now, if that's okay.
Thank you.
How you doing, Chief?
Good, brother. Like that uniform. There you go.
Now, do I have a marked up copy? I'd like the same copy that the chief has. I don't know, I've not looked at it. Okay, sure.
And just so the arbitrator knows, while he's reviewing, these are 4 pages of single space type notes that it could take a while since he's being presented this for the first time.
Yes, okay. We'll take whatever time you need. If we need a recess for him to review them while he's alone, that'll be fine too. We can go off the record. Do you need to go off the record at this point, Mr. Urbis?
Could I go get my glasses? I'm parked right down the street. I mean, right in front.
Yes, let's go off the record. Let's give the chief time to get
Yeah,
his glasses.
thanks. The font's so small, it's very difficult. So
I understand, sir.
Okay.
All right, we're off the record. Is this a clean copy? I see marks on this. Is this considered a clean copy?
That is what we were tendered, sir. It had some notation on it, if memory serves.
Yeah,
I'm going to pull up the discovery.
Sure.
To double check.
I just want to make sure I have this.
Sure, that's the way we got it. With that notation.
Say that again.
We were tendered a copy of the Just let us know when you're ready to go back on record, sir.
We're ready to go back on. Thank you.
All right, we're back on the record. Your witness again, sir.
Chief, I just want to make sure if you just got your glasses and if you still need more time to read that.
Yeah, just give me like a second.
I'll tell you what, we'll just let you tell us
Okay.
when you're ready, okay?
Perfect.
All right.
I'm ready, sir.
All right, Chief. Having had an opportunity to read those notes, I guess the first question is, do you believe those notes are accurate of what transpired in that meeting?
Yes, sir.
Okay. So the meeting started out where you wanted him to give you a Reader's Digest version of who he was, correct?
Yes, sir, that's what I asked for.
And it's my understanding, you tell me if I'm wrong, that your history is that you take into account who a person is when deciding what discipline to issue. Is that correct?
Sometimes it doesn't matter what the person's work history is. Well, let me rephrase that. I always start off, no matter what, learning about that person. Our department is so big that I really want to get a chance to know them a little bit better. And so, but my decision on discipline usually has no bearing on the information that they've given me sometimes. So they could be a stellar employee, but the discipline rises to a level of where their work history, all their accolades, sometimes they don't mean anything.
Okay, I think I got you, but let me see if you can at least agree with this. That sometimes the work history can make the difference when someone's on the bubble as to whether you keep them or not, depending upon, to be fair to you, the nature of the misconduct. Would you agree with that?
I've had great difficulty with that over the years, and not necessarily with a DWI because I think they're pretty clear cut, but I have had instances where the person was an exemplary employee, but what they did rose to the level of being terminated. And so, and this wasn't a DWI case, and so we gave them an opportunity to resign versus being terminated. But with DWIs, I've never had a situation where the quality of their time with the fire department would trump or outweigh what the discipline was.
Okay, but have you taken a person's work history into account in the past on other matters when deciding the level of punishment, when the punishment did not warrant termination?
Objection of relevance.
I didn't get your objection, say.
Relevance.
We don't know what the testimony is going to be. I don't know what his answer is going to be. I'll allow it.
Would
You
you
can argue relevance on.
Would you ask that again, please, sir?
Okay, first of all, I'm not talking about a DWI case, but a case where you've issued discipline where has not been termination. You would agree that in the past, you have considered a person's work history in deciding the level of punishment.
Again, objection on relevance. He just said he's not talking about DWI cases, and under controlling authority by the Texas Supreme Court, this discipline must be based on of a similar circumstance, similar facts, such as a DWI case we're considering, not other disciplines of potentially 2,000 other people under his command.
In response to the objection, we believe we'll be able to link it up in further questions.
Yeah, I'll overrule the objection. I'll allow it. We'll see where it goes. And you can, again, address it on redirect.
Can you please read back the question?
Okay, but have you taken a person's work history into account in the past on other matters when deciding what level of punishment, when the punishment did not warrant termination?
I can't remember a specific situation where I've done that.
Okay. All right. So in this particular case, you received various letters of recommendation by some high-ranking members of your department, correct?
In this case here?
Yes.
Yes, sir.
And those were tendered to you in the meeting, were they not?
They were brought to me. I don't know if it was a meeting, but I did get letters.
Okay, but it says Cerda meeting with Chief Hood on 5/14/2019. That's the meeting I'm referring to.
Okay, yeah.
You received letters of recommendation.
Yes, sir. But sometimes I'll also get an officer, somebody drop a letter off for someone. So that's what I was pertaining to. But yes, I did have letters from Mr. Cerda.
Okay, and I thank you for that clarification. If I didn't make it clear, I apologize. But so that we're on the same page, he presented, hand-delivered to you in this meeting, letters of recommendation from your command staff, correct?
I don't remember it being from my command staff. If you could refresh me, I just don't remember it being from my command staff.
Okay. Now, and I take it you reviewed those.
I reviewed them, but I don't remember the command staff member's name being on there. It's been a couple of years, so I don't remember.
All right, and you reviewed those before making a decision?
I looked at them at the time, but again, the letters of recommendation or commendations, it wouldn't have changed my view of discipline in this situation.
Okay, would it be fair to say that in the meeting you called him a good dude?
Yeah, I'm sure I did, but again, that has nothing to do with what he did in this instance. So we have a lot of our employees that I'm sure Mr. Cerda, he's had a stellar career with this organization, but he made some bad choices in this instance.
Okay, so I apologize. Sometimes I don't listen too well, but I think I heard you say that he had a stellar career. Is that correct?
You know, from everything I've heard about Mr. Cerda, he's had a great career. And so, but we have several people come in that they've had great careers, and the career sometimes what you've done doesn't doesn't mean as much when, you have something like this happen. It's not going to change my decision as far as what your careers looked like in this situation.
I got you. So his work history was not in dispute,
No, not at all.
and he was 1 year, 3 months shy of retirement, correct?
He was eligible for his 20, I think.
All right. And you would agree that he expressed remorse to you about this incident?
Yes, he did.
And he admitted that it was the worst mistake of his life, correct?
Yes, he did.
He attempted to explain to you the circumstances of what happened that night, correct?
That afternoon? Yes. Yes, sir, he did.
And he mentioned to you that he was assigned to another station different from his normal station, correct?
Yes, sir.
And he explained to you that he had trouble with sleep, correct?
Yes, sir. Most career firefighters have trouble sleeping.
And he provided you information about his medical history, correct?
Yes, sir.
And that included taking various medications that caused him issues with sleep and forgetfulness, correct?
Yes, sir.
And so he explained to you how the combination of the deprivation of sleep and the medication and the drinking contributed to this incident, correct?
Yes, sir.
All right. And now I realize sometimes with the passage of time, memory may be imprecise. And I want to make sure I understood what your testimony on direct was compared to what the notes are. It's my understanding that your testimony on direct was that he said that he was with his brother to you on May 14th, 2019. Would you agree that based upon the notes, he did not say that he was with his brother when he was arrested?
Basically, what I told you was that he referenced or mentioned that he was with either his brother or his brother-in-law. They had gone to look at some wheels, and he thought his brother was in the vehicle with him.
Okay, he didn't say that in the meeting with you, did he?
That's the only time I've ever been with him.
Okay, but you read the offense report, I take it?
This report you're giving me right here?
No. The offense report, which was, I believe, is City Exhibit 3. What I'm trying to get at, Chief, is there's a difference between you having a recollection of what Cerda said based upon a police report and based upon his meeting with you. And I want to make a distinction that he may have said he was with his brother in the police report, but in the meeting with you, he never said he was with his brother, did he?
To my recollection, he did.
Okay, but it's not reflected in the notes, is it?
That could be. I'm not sure, but I do remember that.
All right.
I'd have no other way of knowing that if he didn't say it.
Well, okay, are you telling me that you didn't read the police report?
Well,
before
I
you met with him?
I did read the report, but again, it might not have made the documentation for whatever reason, but I do remember that.
Okay. And during the meeting, he attempted to show you photographs?
I can't remember photographs.
You don't remember because you didn't look at them or what?
I don't remember getting photographs is what I'm trying to say.
All right. And you had asked Cerda if he had seen the video before the meeting with you, correct?
Yes, sir.
And he told you he had not seen it and he's been trying to see it?
Yes, sir, that's correct.
All right. Now, you did tell him that he had an unblemished career, correct?
Yes, sir.
And you told him that he was a really good guy, right?
Yes, sir.
And you told him that despite the fact that he's a really good guy, that you had no choice other than to give him the indefinite, correct?
Yes, sir.
And you told him, I can't delay the discipline waiting on something that may come up. That was in reference to the criminal case, correct?
Yes, sir.
So you decided that notwithstanding how it may turn out in the criminal courts, you had no choice but to terminate him, correct?
Yes, sir. We felt that we had enough information between the police report, the emergency room information, the video was very telling, and then the interview from him didn't really produce anything else. So yes, we felt we had enough information.
And so the fact that you believed that he engaged in criminal conduct was the reason for you making the decision to terminate him?
Yes, sir.
Okay, would you agree with me that you have not terminated other officers who've been indicted for felony charges?
That's correct.
And you have awaited the outcome of their criminal case, correct?
Those cases would be domestic abuse cases where we were waiting for either the DA to file or something like that. And so we would put them as services. We have since created another rule that we, if I have a firefighter and they've left marks on someone, if we have physical evidence in a domestic case, then we will fire them instead of waiting. But we have had a couple of our firefighters be involved in domestic cases where we had to wait to see what the DA was going to do. And actually one, we released him back in the field, and then DAs changed and they opened up the case again.
All right, but there are some people that you haven't fired that are under criminal charges now, correct?
Yes, sir.
All right. And so when you said you can't delay the discipline, that would be inconsistent with allowing domestic violence cases to play themselves out in the court, correct?
Well, we're talking about a DWI versus a domestic.
All right. And so you saw the aggravating circumstance in this case to be the evading, correct?
Evading?
Yes.
One of them, yes, sir.
All right. And it turned out that no evading charge was presented to the grand jury, correct?
Gentlemen, calls for speculation.
I don't know.
Okay.
I'll allow him to answer, and I believe the record will reflect that he answered, I don't know.
Let me rephrase. You never received notice from the district attorney's office that he was indicted for evading arrest, correct?
And we're going to object to this line of questioning. We were prohibited from talking about the plea agreement yesterday Mr. Cerda entered into, and now Mr. Swintus is getting into the same criminal matter in this case.
That's true, Mr. Cifuentes. What's
Alrighty.
changed between yesterday and today about that subject?
I'll move along, ask another question.
Okay, objection is sustained.
Now, you also indicated that you didn't think that this would ever happen again when you met with him, correct?
Yes, sir.
All right, and you mentioned that some of the other firefighters that you've met with have attitude problems because they're smug, correct?
Because they're what?
Smug.
In reference to, I'm not understanding the question.
Okay, in the notes, you didn't see how you referenced that some other firefighters can be smug when they're in the situation they're in?
Yeah, I mean, sometimes firefighters, their body language is spin around in the chair. There's no contrition, just depends on what. So, yes, sir.
Okay, and you didn't notice any of that when you met with Cerda, did you?
Not at all.
All right. And you told him that you wish that you had another option other than to let him go, correct?
Yes, sir.
And you told him that you were hoping to get information from the district attorney that some or all of the charges were no longer an issue and had been dismissed or reduced, correct?
To my knowledge, yes. I mean, if he had the opportunity to fight to get his job back, if information came up, then he should do that.
Okay, and so on COSA Exhibit 0047 that's before you,
Which one, what tab number?
That's non-exhibit.
it's the notes of the meeting.
Oh, I'm sorry. What page again, sir?
0047.
Yes, sir. What am I looking at again?
On part of, at the top 1/3, you said you're a part of a pattern of some guys who have gotten DWIs and done some dastardly things after they get pulled over.
Yes, sir.
All right. And would you agree that you're talking about circumstances that relate to the arrest?
Yes, sir.
All right. And
Or the arrest, or in a couple situations, or a situation that I know of, before the arrest even happened.
all right. And so as far as the guns being pulled, that was the conduct of the officers, correct?
The conduct of the officers?
Yes.
The officers pull the guns?
Yes, that wasn't Cerda's conduct, was it?
Well, I think because he evaded, they probably felt they needed to draw the guns. I don't know what was in their head for drawing the guns.
Okay, but you saw that the rookie officer didn't pull his gun.
I didn't know how much time he had on, but
But you saw that he didn't pull his gun, correct?
Objection of relevance.
I don't know I just saw officers.
Just a minute, sir, we have an objection.
Relevance, I mean, it mischaracterizes the video. I mean, video speaks for itself on the events that evening.
Well, I'll agree. We talked a lot about that video yesterday. I'll allow the question. We'll see where it goes. You could readdress.
You remember the rookie didn't pull his gun, correct?
I don't remember which officers pull their guns. I do remember an officer walking up and they stopped him, somebody else stopped him, he kind of backed up, but I don't remember who pulled guns.
Okay, did you talk to any of the officers before you made your decision?
No, sir.
Would you agree with me that the rookie officer had observed Cerda longer than any of the other officers?
I wouldn't know. I mean, I guess the rookie officer pulled him over, so he'd probably see him longer, but I didn't talk to any officers, so I don't gauge who spent the most time with Mr. Cerda.
Okay, so did you bother to talk to the rookie officer as to why he was not afraid enough to pull his gun?
Yes.
Given that he was the one who had seen Cerda the longest.
No, sir, we did not interview the officer.
Okay, and so would you agree that the other officers only participated in the last 0.2 of a mile?
I don't know how many vehicles were behind the one officer in the car in pursuit. I can't speculate on that. I don't know.
All right. Now, in the notes, Cerda, on page 0048, it has in parentheses that Cerda handed you reference letters. Those were the recommendations from various members of the department.
Yes, sir.
All right. And you received those letters of recommendation and considered them, correct?
Yes, sir.
So you would have read them, right?
I looked at them, yes, sir.
All right. And okay. Can you go to Union Exhibit 61 through 66?
61?
Yeah, 61 through 66.
Mr. Arbitrator, we're going to object to the introduction of these exhibits and discussions. They're clearly hearsay, and we're not, these witnesses are not here for us to cross-examine. So as far as being asserted to prove the truth of what they're alleging in the letters, we would object.
I understand. I'll let them in for what they're worth.
My book blew up.
Do you want my assistant to help you put that together?
Hang on. I'm at 61 at this time, though. Yeah, I'll take some help.
Okay. Can you help the chief out, Naomi?
We'll go off the record.
Thank you. Mr. Fuentes, off the record? Are you considering, when you say command staff, are you considering my assistant chiefs and deputy chiefs? Or when you say command staff, are you referring to my battalion chiefs?
We'll put that back on the record.
Okay,
That's a good question.
yes, because I see letters here, and so I would like to clarify that. Yes, sir, I'm ready. Sorry.
I just caution you, Chief. I know you have some things to say, and your counsel will have an opportunity to come back and ask you questions.
Okay.
Be responsible.
Yes, sir.
Okay, we're back on the record.
Okay, Chief, Exhibit 61, would you agree that's one of the letters you received?
Yes, sir.
And could you tell us who that's from and who that person is?
Russell Johnson is a battalion chief, Battalion 2.
All right. And he had good things to say about Mr. Cerda, correct?
Yes, sir.
And 62, who's that from?
Luis Cervantes.
And can you tell the hearing examiner who that is?
He drives Russell Johnson. He's his driver.
So he's a member of the fire department?
Yes, sir.
And what rank is he?
He's an engine. I'm not sure whether he's an engineer or firefighter. At that rank, you could be a firefighter or an engineer. I'm not sure.
Okay, and he had positive things to say about Mr. Cerda, correct?
Yes, sir.
And Exhibit 63, you received that, correct?
Yes, sir.
And that's from Saul Obregon.
Yes, Saul Obregon.
And can you tell us who he is?
He just made lieutenant. Works at Engine 25.
All right. And he had positive things to say about Mr. Cerda, correct?
Yes, sir.
And 64, who is that?
Brandon Gonzalez.
And is he a member of the fire department?
Yes, sir.
And what rank is he?
He's an engineer.
And he had good things to say about Mr. Cerda, correct?
Yes, sir.
And Jose Ariola III is 65. Can you tell us who he is?
He's a firefighter on the job. I don't recognize the name.
He had positive things to say about Mr. Cerda, correct?
Yes, sir.
Now, would you agree with me that based upon your investigation, you could not find anything negative by anyone to say about Mr. Cerda as an employee firefighter, correct?
Objection
correct.
mischaracterizes the testimony.
Restate your question again, sir, please.
No one came to you and told you before your decision that he was a bad employee. Would you agree with me?
And your objection was?
Mischaracterizes the evidence as he doesn't limit it to these friends' letters, but other employees investigated and found facts related to the incident apart from these letters that reflect on his performance as an employee.
Well, this is cross-examination. I'll allow some latitude. Objections overruled.
All right. And let's go to your notes. COSA 0046.
Yes, sir.
Would you agree that Mr. Cerda indicated to you that he had had issues with passing out because of his health situation without any alcohol?
Yes, sir.
And he provided you information about his medical conditions, correct?
Yes, sir.
Now, it's my recollection that you stated that after the new policy that was implemented in December of 2014, you have terminated a firefighter other than Cerda without offering a settlement agreement. Is that correct?
Yes, sir.
And you use the word terminated, but I know that people use terminated and indefinite suspension interchangeably, so I'm not giving you a hard time about that, but it was actually an indefinite suspension, correct?
Yes, sir.
And so it's not a termination until the suspension is upheld, correct?
You're correct.
All right. And you would agree that that termination is on appeal and awaiting a decision of an arbitrator, correct?
Yes.
All right. So, and I realize people use termination and indefinite suspension interchangeably, but to be precise, he has not been terminated yet, correct?
Indefinite suspension.
So you agree with me, he has not been terminated yet?
Mr. Cerda?
No, the other person that you've talked about.
No, he is not.
Okay. Now, in your meeting with Cerda, you explained to him that you were forced to fire him because of what other firefighters had done, correct?
Yes, sir.
You didn't say that you found his behavior egregious anywhere in those notes, did you?
No, sir.
You agree that you never explained that his conduct fell under the circumstances surrounding the arrest required his termination. You never explained that in the meeting, correct?
No, sir.
You agree with me?
Yes, sir.
All right. We would offer COSA bait stamp 0045 through COSA 0048 at this time.
We object to the extent that it's admitted as a summary of a meeting. Today, we have a court report taking on every word of this proceeding. That meeting did not have such a transcript. It's merely a synopsis. So there are things said not included in those notes. If we will admit it with that provision.
I understand. It's admitted, and for housekeeping purposes, yesterday we had a motion in Lamine that was accepted into evidence. It was originally labeled appellant number 1, but the motion in Lamine should actually be appellant number 67. So I'm going to change that on my copy. And the notes that the chief has been testifying from are admitted as appellant number 68. You may continue.
Now, Chief, would you agree with me that you have always taken the circumstances surrounding the arrest of a firefighter into account when deciding the level of punishment, whether it's for DWI, assault, or otherwise?
Objection to the extent it seeks pre-December 2014 occurrences.
We're going to link it up.
Not being relevant.
We're going to link it up.
You're going to link up with cases from 7 years ago?
Yes.
I'll allow it. Let's see where it's going. It's testimony. You can readdress it. You can listen to it, object to whatever you want during it.
Can you please read the question back?
Before you offered 45 or after offering 45? Page 45. I'm looking for it. You agree that you never explained that misconduct or the circumstances surrounding his arrest. You never explained that to me, would you?
No,
Before that,
no, the last question that I asked before the objection.
there.
In the interest of time, do you remember your last question, sir? We'll just have you restate your question to keep things moving.
I've just been reading discussions of Mr. Capel's objection. Okay, here it is. Here it is. Now, Chief, would you agree with me that you have always taken the circumstances surrounding the arrest of a firefighter into consideration for our charge?
So let me rephrase. You would agree that when deciding punishment of a firefighter that's been arrested for a criminal offense, you've always taken the circumstances surrounding the arrest to determine the level of punishment, correct?
Yes, sir.
All right. And since you've always taken it into consideration, when it comes to DWI, you always previously took circumstances surrounding arrest into consideration, correct?
Yes, sir.
And so you would agree that there have been DWIs that occurred before you issued the indefinite suspension, where you took circumstances into consideration where the officer engaged, not the officer, the firefighter engaged in misconduct other than the mere DWI. Would you agree?
What years are you talking about?
Before the 2014.
Yes.
All right. And in some of those DWI cases, some of the egregious circumstances have include car crashes, correct?
Yes, sir.
Objection again, relevance to pre-policy that applies to this case.
I'll allow you to argue relevance. I'll allow the testimony.
And some of those car crashes have been car crashes where a firefighter has crashed into an SAPD patrol vehicle, correct?
Yes, sir.
And in that case, you did not terminate the firefighter that crashed into an SAPD patrol vehicle, correct?
Yes, sir. We didn't have a policy in place that looked at some of the things that we were dealing with back then. This is when we were having, up to 19 DWIs in a year. So that's one of the reasons that we created this 2014 policy.
I got you. But did you explain how after this individual crashed into an SAPD patrol car, caused extensive amount of damage, I believe it was to two vehicles, correct?
Yes, sir.
And that was several $1,000s worth of damage, correct?
I would imagine, yes.
And the two police officers that were on scene had to jump over a retaining wall to avoid being hit, correct?
That's correct.
And had they not jumped over that wall, there was a chance that they might be injured, correct?
Yes, sir.
And one of the officers was a female officer named Brianne Martin who injured her ankle, correct?
I'm not sure the name of the officer.
But she did.
She did, there was
Yes.
an ankle injury.
Okay, so what memorandum or instructions did you put out after that crash? And when you implemented the 2014 policy that injury or crash would be a circumstance that you would take into consideration?
The memo that we did in 2014 took into account everything that we'd learned from past DWIs and the things that we weren't going to tolerate in the future. Talk about circumstances if this crash would have happened in 2014 or, anytime after that, this firefighter would have lost his job.
Okay. But did you explain that after you issued your 2014 memorandum?
As far as what the circumstances were?
Yes.
No, we're not going to provide a menu of if you kill somebody's dog or if you do this or if you do that. I don't know what the circumstances are, so that's why it's circumstances that we don't know what they're going to be when someone's pulled over with a DWI. I don't know what that's going to be.
Okay, so would the only way for firefighters to know what you consider to be egregious conduct was based upon how harshly you treated DWIs previously?
Objection mischaracterizes the testimony.
It's a legitimate question. I'll allow it.
Could you repeat that, please?
Is the only way for firefighters to know how harshly you would treat future DWIs after 2014 would be based upon how harshly you treated DWIs previously?
I'm getting to the mind of a firefighter, so I don't know.
Okay, so that poses an interesting question. So based upon what you've done and based upon your answer to my last question, you have no way of knowing what firefighters should expect when a new DWI happens after your new policy, correct?
Well, first of all, we'd expect our employees not to get a DWI. We would expect if they were stopped by the police that they would stop. So I think there's some common sense things that our employees would understand as far as the circumstances that could get them in more trouble.
So before you issued your December 2014 policy, is it your contention that before 2014, you would never fire or issue an indefinite suspension to a firefighter who picks up a DWI?
That I would never fire?
Was it your discipline policy before 2014 not to fire based upon a DWI?
Yes, it was.
So you wouldn't fire just for a DWI before 2014?
No, coming into a situation as I did in 2007 and a culture of protecting, enabling, giving DWIs a second chance. That was the culture that I arrived to. And so once we started looking at some of the DWIs since I got here, a lot of them were multiple offenders. And so what are we going to do to break this cycle? And one of the things is like, okay, they can't be at work. They can't sit in the back of the truck or drive or not drive. We have to take them off their work situation, not allow them to be at the station, not allow them to work overtime. There were things that we looked at doing to break this cycle of multiple DWIs. But again, that was the culture in this city when I arrived in 2007.
Now, can you look at the union exhibit number 2?
For the record, we're going to object to this as a policy that was implemented after this incident. So it has no application. It's not relevant, doesn't meet Texas Rule of Evidence 403. It merely confuses the issues, potentially misleads the arbitrator, and is cumulative and just unnecessary. Its probative value is outweighed by the potential to confuse issues in this case.
Well, there's no way for the hearing examiner to make that determination unless he considers some evidence, and then he can decide whether to exclude it.
Well, he can look at the date of the letter and see it clearly doesn't apply to an event that happened before this policy.
Do you agree this was issued after the appellant was terminated?
Yes, but the only difference is that between the two is that he raised the minimum punishment on a settlement from 60 days to 90 days. So he still offered settlement agreements afterwards.
I'll sustain the objection. It's similar to disciplinary action that occurs after an incident. It would be irrelevant. This policy is irrelevant. The objection is sustained. Appellant, union exhibit number 2 is disregarded.
All right, and can you look at exhibit number 3?
Yes, sir. Yes, sir.
And you would agree that you declined to terminate Reagan Connolly when he was convicted of insurance fraud?
Objection. This is a 2018 event. Clearly,
2008.
I'm sorry, 2008. Clearly, years before the policy that applied to this case. So it has no application. It's should be excluded.
Well, we assert that insurance fraud in the amount of 193,000, or I'm sorry, insurance fraud, the indictment was a felony. It's a crime of moral turpitude. And if you're looking at similar violations of rules, conduct and discredit, negative publicity, and so forth, that the egregiousness of insurance fraud is far worse than an obstruction of the highway.
And if Mr. Swinces is trying to tee up a disparate argument claim, Texas Supreme Court ruled 3 years ago, 2018 case of Alamo Heights Independent School District versus Clark, that an employee, what should be considered are employees similarly situated if their circumstances are comparable in all material respects, including similar standards, supervisors, and conduct. This was years before a totally different situation, not a DWI, not an arrest, different policy. So it really is no relevance to this case.
So the Supreme Court decision that he cites is inapposite for the simple reason that it's not applying Chapter 143 or Chapter 174. And so 174 creates a system where arbitrators can use rules of arbitration to decide what's just cause. And just cause that we're suggesting to this arbitrator that if someone is not fired for committing a felony that's a crime of moral turpitude, then someone should not be fired for a DWI that's been reduced to an obstruction.
Again, it's pre-policy 11 years before the December 2019 policy.
Well, in the interest of fairness, I'll cut to the
2014.
chase. If you want to talk about it, it's in your book. It's from 2008, 12 years ago, 13 years ago. I will disregard it, but you may talk about it if you'd like.
All right. So you would agree that Reagan Conley was charged with a felony, correct?
Yes, sir.
And a jury convicted him, correct?
Yes, sir.
And nevertheless, he was reinstated, correct?
Yes, sir.
All right. And exhibit number 4.
And city objects to this 2009 incident, clearly pre-policy to the 2014 DWI policy.
And my response is the same. I'll allow, in the interest of fairness, I'll allow the union to explore it. I'll disregard.
All right. And he was arrested for DWI on September 20th, 2009, correct?
Is this the first one or the second? He was arrested a couple times.
That's correct. And I'm glad you remember that. He got a 15-day suspension for the first one, correct?
Yes, sir.
And then he picked up a later suspension, a second DWI, correct?
Yes, sir.
And when he picked up the second DWI, you didn't fire him for that, did you?
No, sir.
All right. And that's on, the second DWI is exhibit 5, correct?
And can we have a running objection to the, or I can object to each one individually? So these are
The
all,
objection is on the record. I'll overrule the objection to the extent that I'll allow counsel to talk about it in the interest of fairness. Anything that's pre-policy, I'll disregard.
All right. And on April 19th, 2009, he picked up a second DWI, correct?
I'm showing April 22nd on my,
Okay. He picked up another DWI in 2009, correct?
yes, sir. Okay, I see the top, but I'm seeing April 22nd here. Yes, sir. April 19, 2009.
And he got a contemplated indefinite, but then you changed it to a 25-day, correct?
Yes, sir.
And he got pretrial diversion on that second DWI, correct?
Yes, sir.
So the fact that he got pretrial diversion, was that why you didn't fire him?
The policy was not in place yet.
Okay, but my understanding is you did give him a contemplated indefinite, correct?
Yes, sir.
And even though the policy wasn't in place, you did testify that you took the circumstances surrounding the arrest into consideration previously, correct?
Yes, sir.
And so would you agree that if someone picks up a second DWI, you take that into account as a circumstance surrounding the arrest, correct?
Object as to the time frame. What we're talking about here. There's current policy and something 10 years ago being discussed interchangeably.
Understand.
It's confusing.
My ruling is the same. You may continue.
So you take a second DWI into consideration as a circumstance surrounding the arrest, whether it's before or after 2014, correct?
Yeah, I took it into consideration, yes.
All right. And then Exhibit 6, you gave Maurice Bramer a 15-day suspension, correct?
Same objection is that this is a 2010 for the record.
So noted.
Yes, sir.
And then on Exhibit 7, you gave Eric Wolf a 15-day suspension for DWI?
Same objection.
Correct.
The objection's noted.
And then on Exhibit 8, you gave Stephen A. Boldway a 90-day suspension for a DWI?
Same objection of relevance that we're into 2011.
Correct.
So noted.
And Stephen A. Boldway was the officer who crashed into a patrol car, correct?
He was a firefighter, yes, sir.
Yes, the firefighter that crashed into a
Yes, sir.
San Antonio Police patrol car.
Yes, sir.
And he destroyed two vehicles in his own, correct?
I don't know if he destroyed, but he damaged.
And then one of the police officers had to jump out of the way to avoid being hit, correct?
Yes, sir.
And she suffered a sprained ankle, correct?
Yes, sir.
And it could have been life-threatening. Would you agree?
Absolutely.
On Exhibit number 9, Lee Stample got his third DWI arrest, correct?
Objection of relevance.
Understand.
Yes, sir.
And that was on October 25th, 2012, correct?
I'm seeing August 11th, 2012 at the top,
Okay.
and I'm seeing the 27th of October on the date here.
Okay, so he actually had an arrest on September 20th of 2009, one on August 11th, 2012. And even though this was his third DWI, you only gave him a 15-day suspension, correct?
Yes, sir.
And so the previous DWI, he had a 25-day suspension, but on the third DWI, he only got a 15-day suspension, correct?
Yes, sir.
All right. And on Exhibit 10, you gave Damian Sines a 15-day suspension for DWI, correct?
Objection of relevance.
Correct.
And on Exhibit 11, you gave Patrick Higgins a 15-day suspension, and that happened July 25th, 2014, correct?
Objection of relevance.
Yes.
Understood.
And this was less than 5 months before you made the change in policy, correct?
Yes, sir.
And so was this part of the pattern of a spate of DWIs that you found intolerable?
Yes, sir.
Okay, so given that it was a part of a spate of DWIs that you found intolerable, you only gave a 15-day, correct?
That's correct.
All right, and then Christopher Hildebrand in Exhibit number 12, he was arrested on July 26, 2014, correct?
Objection of relevance.
Well, I'm hearing counsel's relevance. We had previous testimony from the chief that there was a culture of permissiveness toward DWI. And I see that we're having a repetition that reinforces that testimony of the culture. So I'm going to accept this. I'm going to overrule my previous directive, and I'm going to allow it in as relevant.
Oh, it's only, the objection is a pre-policy relevance. It
I
was under a different
understand,
policy.
but I'm going to take this into consideration now.
All right, so Exhibit 12, Christopher Hildebrand got a 15-day suspension, correct?
Yes, sir.
And he was arrested on July 26, correct?
Yes, sir.
But you issued discipline to him on November 5th, 2014, correct?
Yes, sir.
And so you issued the 15-day suspension 1 month before you implemented the new policy in December 2014, correct?
Yes, sir.
And would you agree with me that the next DWI that you issued was Exhibit 13 on Damien Signs,
Yes, sir.
and you picked up a second DWI, and the date of the arrest was September 12th, 2014, correct?
Yes, sir.
And even though his arrest was before you implemented the policy, you suspended him after the policy, and you gave him an indefinite suspension, and you gave him a settlement and release of 90 days.
Yes, sir.
All right. So can you tell me what prohibited you from firing Damien Signs, Patrick Higgins, or Christopher Hildebrand, which were in the year before your policy change?
Higgins and Hildebrand didn't cause damage to any vehicles. There was no issues with them being arrested or during their incarceration. And so those are the reasons for that. But again, it points out a culture and a pattern of our members. Damien Signs, again, it was his second. He was disciplined very severely with 90 days, but there were no other circumstances that surrounded the arrest or accidents, injuries, or anything like that.
Okay, so would you agree the pattern or culture didn't just happen in a vacuum? You were a participant in this culture.
I was an active participant, and that's why we've gotten 2 different DWI memos over the years.
Okay, but prior to 2014, you didn't do anything to crack down on the DWIs, did you?
Objection mischaracterizes the testimony and the evidence in this case.
Overruled, I'll allow the answer.
Repeat, please.
Before you issued the indefinite suspension to Damien Signs, you didn't do anything to crack down on the consequences of DWI, correct?
That's a difficult question to answer because that's just a difficult question to answer.
Okay, let's take a look at Exhibit 14. That's on Eric Wolf,
Yes, sir.
and you gave him an indefinite, and then you agreed to a 90-day suspension for a second DWI, correct?
Yes, sir.
And his case is interesting because he picked up, actually, he failed to report to duty on August 8th, 10th, and 16th of 2014, correct?
Yes, sir.
And then he picked up a DWI in Austin in the summer,
Yes, sir.
and he picked up 2 DWIs in November.
Same incident, same date, yes, sir.
And then he was accused of lying about the November 1st limousine crash.
Yes, same incident.
All right. And then his settlement agreement was signed on December 18th, 2014, after your policy, correct?
Yes, sir.
And so would you agree that missing work, being involved in two DWIs, and lying about a limousine crash are all circumstances related to the issue of alcohol abuse and DWI?
Yes, sir.
And despite those being circumstances surrounding his DWI, you did not terminate him, correct?
Correct.
Now, Albert Salazar,
Is that 15?
yeah. On November 17th, 2015, this was an arrest that happened after your new policy, correct?
Yes, sir.
And he had an open container of hard liquor inside the vehicle, correct?
Yes, sir.
And that would be an aggravating circumstances surrounding the arrest, correct?
Yes, sir.
And even though there was an aggravating circumstances surrounding the arrest, he was not fired, correct?
That's correct.
He was given a 60-day suspension and a settlement and release agreement, correct?
Yes, sir.
Now, Adrian Garza was arrested on Exhibit 16, was arrested for DWI,
Yes, sir.
signed a settlement and release agreement.
Yes, sir.
And was not terminated. Would you agree?
Yes, sir. He did not evade, be involved in a chase, have a weapon, open container in his vehicle. So, yes, I agree with you.
All right. And on Exhibit 17, Ryan Pollock got a 45-day suspension after being issued an indefinite suspension.
Yes, sir. And again, he was not involved in any type of pursuit, chase, evasion, weapon, or open can in his vehicle.
All right. And there was a gun involved in the arrest, correct?
Excuse me?
There was a gun involved in the arrest, correct?
In Pollock?
In Pollock, yes.
Yes, sir, but there again was no evasion involved.
And would you agree that Pollock was not the upstanding type of firefighter that Cerda was? He had previous discipline?
I don't know what Mr. Pollock's history is at this time.
You don't deny that he had previous history, do you?
I can't remember. I've got 1,875 members, so I can't remember Mr. Pollock's history.
And the officer asked Pollock if he had a weapon in the car, and he didn't tell him the truth, did he?
Correct.
And also Pollock ran over a street sign and damaged it, according to the KSAT News, correct?
I think he backed over something, if I
So,
remember.
so you agree that he got negative publicity on that case, correct?
We get negative publicity on all our DWIs.
Okay, so on this particular case, there was negative publicity on the news on that case, correct?
Yes, sir, negative publicity on each and every one of these.
All right, and let's take a look at Monaco Vasquez.
Are we just going sequential?
Yeah,
Okay.
Exhibit 19. See, we're getting used to each other, Chief.
Did you say 18? I'm sorry.
19.
Okay, we skipped Frazier.
Oh, you know what? I'm glad you mentioned that. Thanks so much. On Exhibit 18, that's Eric Frazier, correct?
Yes, sir.
And he got a 60-day suspension. Would you agree?
Yes, sir.
And within the month after entering the settlement agreement, he failed to notify the fire department that he entered a plea on the DWI shortly thereafter.
Yes, sir.
And so he didn't notify the department about the outcome of this case, correct?
Correct.
And you would consider that as being less than candid with you per what he agreed to do, correct?
Yes, sir.
And so someone who's less than candid and doesn't keep his word, that's indicative of dishonesty. Would you agree?
Yes, sir.
And so instead of firing him after the settlement agreement, you only gave him a 5-day suspension for failing to abide by the settlement agreement.
That's affirmative. Again, he wasn't driving, wasn't evading, didn't have open liquor or gun in his car.
But you would agree with me that his agreement to keep you updated related to the DWI arrest, correct?
Yes, sir.
And so in that sense, it relates to his later misconduct was a circumstance relating to the arrest, correct?
After the fact, yes.
All right. Now, let's talk about Exhibit 19, Monaco Vasquez.
Yes, sir.
Monaco Vasquez received a 60-day suspension for a DWI arrest, correct?
Correct.
And even though you had already fired Cerda and one other officer, you never explained to firefighters why they deserved termination and these other people that followed didn't get terminated, did you?
No, sir.
All right. In Exhibit 20, that's Lieutenant Abel Gomez. He got a 90-day suspension. Would you agree?
Yes.
And would you agree that as a lieutenant, he is of a higher rank than Cerda?
Yes, sir.
And you agree, you've testified previously that you hold people of higher rank to a higher standard?
Yes, but again, he wasn't evading, didn't have open can, there was no weapon in the vehicle.
Okay, and would you agree that he failed to notify you of his DWI until after it hit the news?
Yes, sir.
And would you agree that his failure to notify you afterwards relates to the circumstances surrounding his arrest?
Circumstances afterwards.
And would you agree that the failure to disclose is indicative of a lack of honesty?
In this situation?
Yeah, you agree, yes?
Yes.
Because he had a duty to disclose that to you, correct?
Yes, sir.
So that made his misconduct more aggravating, would you agree?
Not compared to evading arrest with an open can of beer and a weapon in your car.
Okay, so you would agree that it's more aggravating, correct? Yes or no?
Objection asked and answered.
He's not answered it.
He can answer again.
Yes or no, when you lie and by failing to disclose, you were arrested for DWI, that makes your conduct more egregious, correct?
Not compared to evasion with a weapon in your vehicle.
I'm not asking you to compare it to anything else. I'm just asking you if it's more egregious, yes or no?
Objection. The witness is allowed to explain his answer.
I'll sustain the objection. I understand his answer.
All right. Let's also talk about Gomez. His blood alcohol level was 0.15, correct?
Yes, sir.
And you understand that in the state of Texas, that the legal limit is when you exceed 0.08, that it's a DWI Class B, correct?
Yes, sir.
And when you reach 0.15, it becomes a Class A, which is a more serious offense, correct?
Yes, sir.
And so would you agree that the higher the level of intoxication, the more egregious a case is, correct?
I think it would depend on the circumstances.
All right, so you would agree that the state legislature, the state of Texas considers it a more serious crime when it's 0.15.
Objection calls for a legal conclusion.
The chief has not held himself out to be an attorney. I'll sustain the objection.
All right. So let me just ask you, do you understand that a Class A misdemeanor is more serious than a Class B misdemeanor, correct?
Yes, sir.
Okay, so you know that 0.15 is more serious than below 0.15, correct?
Yes, sir.
All right. Now, Stephen Tejeda, that's Exhibit 21, would you agree?
Yes, sir.
He was given a 60-day suspension for DWI?
Yes, sir.
All right. And Tejeda refused to provide a breath specimen, and they had to get a search warrant to draw blood, correct?
Yes, sir.
So the fact that he did not cooperate, you didn't consider that an aggravating circumstance that warranted termination, correct?
No, sir.
All right. Let's talk about Exhibit 22. That's David Morales.
Yes, sir.
You gave him an indefinite suspension and reduced it to a 75-day.
Yes, sir.
And the aggravating circumstance in that case was that he had a car crash, correct?
Yes, sir.
And he rear-ended another vehicle, correct?
Yes, sir.
And that was at Northwest Military in Wurzbach, correct?
Yes, sir.
And it was on Wurzbach Parkway?
Northwest Military near Wurzbach Parkway.
And he rear-ended another vehicle that was stopped at a traffic light, correct?
Yes, sir.
And it caused considerable damage to both vehicles, did it not?
I don't remember what the damage was. I'm sitting here trying to remember that right now. I don't remember.
All right. And even though he crashed into another vehicle causing property damage, you did not terminate him, correct?
Yes, sir.
And in the case of Cerda, he only caused property damage to his own vehicle, the tailgate, when he couldn't maneuver his vehicle correctly.
He was evading arrest in that process, though, with a weapon in his car and a beer. That's the
Okay.
difference.
So answer my question. My question relates solely to property damage. I know you want to explain things, but the only property damage caused was to his own vehicle, correct?
Yes, sir.
All right. And let's talk about Exhibit 23, Jesus Cuevas.
Yes, sir.
He got a 75-day suspension, correct?
Yes, sir.
And I know that you like to talk about the weapon in Cerda's case, but Cuevas also had a UCW involved, correct?
A what?
A weapon.
Yeah, what did you said a U?
On Exhibit 23, you would agree that Cuevas had a weapon, correct?
Yes, sir.
All right. And you didn't fire him, did you?
No, sir.
And he had above a .15, correct?
Yes, sir.
And he didn't have a permit to carry, correct?
I'm not familiar, I'm not aware.
Okay, and so you're aware that the reason no UCW charge was filed against Cerda was that he was a licensed permit holder, correct?
Yes, sir.
So you knew that the charge of carrying a weapon was not a valid charge against Cerda when you terminated him, correct?
Yes, sir.
All right. But you knew that in Cueva's case, that the unlawful carrying was a valid charge, correct?
Yes, sir.
But you did not terminate him,
Correct.
all right? And am I correct that Cuevas was operating his vehicle on one rim?
Yes, sir.
Now, what is your understanding of him driving his vehicle on a rim?
He didn't realize he had a flat, I think, or something like that.
Okay, and so driving on one wheel is a dangerous situation, would you agree?
Yes, sir.
And that would contribute to the possibility that being intoxicated and not having a tire on one of your wheels creates a greater risk of collision or harm to the motoring public.
I think police chasing you causes the same
Chief,
dangers.
Chief, please answer my question.
Yes, sir.
Having a level of intoxication that's twice the legal limit and driving on a car that has a missing tire, that creates a greater risk of harm to the motoring public. Would you
Yes,
agree?
sir. Absolutely.
All right.
Can we take a bathroom break?
Can we go off the record?
Yeah, we'll go off the record. We'll take, give the court reporter a chance to rest her fingers. Let's take 10 minutes.
Thank you.
And also, sir, I would just caution you, don't talk to counsel during your break. You're under testimony
Yeah,
right
that's
now.
fine.
Okay, we're back on the record. Oops, we'll wait for the court reporter to give us the sign. Okay, we're on the record. You may continue.
Okay, Chief, we're still going to be talking about Cuevas,
Yes, sir.
and that's Exhibit 23.
Yes, sir.
Do you recall in your prior testimony that the circumstances surrounding Cuevas' arrest that led you to increase punishment from the standard 65 days was owing to, number one, he was twice legal level. He was driving on a rim. He lied to the police about a handgun. And lastly, he had a handgun, that you took those four factors into consideration to increase his punishment by 15 days above your standard.
Yes, sir.
All right. And exhibit number 24 is Lieutenant Geraldine Casals. And would you agree that she was intoxicated and got into an altercation with a male at Worstfest in New Braunfels?
Yes, sir.
And she pushed and took a swing at a police officer, correct?
Correct.
And pushing a police officer and taking a swing at a police officer could be considered aggravated assault, correct?
Yes, sir.
And after she took a swing at the police officer and after she was arrested, she was belligerent all the way to the jail, correct?
Yes, sir.
And even though she was a lieutenant that should be held to a higher standard, you did not give her an indefinite suspension for her alcohol-related misconduct.
That's correct. She wasn't behind the wheel.
All right. And taking a swing at a cop is a more serious criminal offense than DWI. Would you agree?
Objection calls for a legal conclusion.
Sustained.
Let's take a look at, I believe it's going to be tab 25, which should be Maurice Bramer.
Yes, sir.
He had 3 DWI arrests, correct? Or he had 3 arrests that he failed to disclose, correct?
Yes, sir.
And by failing to disclose one of them, he got past the 180-day mark, correct?
Yes, sir.
And the only reason you found out about his prior DWI was when they did a criminal history check on his paramedic training, correct?
That's correct.
And so concealing that information was an act of dishonesty, correct?
Yes, sir.
And firefighters often have to testify in court, correct, as part of their duties?
Yes, sir, sometimes.
And would you agree that if a firefighter is dishonest, the district attorney may not sponsor that firefighter as a witness?
Objection calls for speculation.
If he knows the answer, I'll allow him to answer.
I'm not aware of, I don't know.
You never been told by anyone that there's a thing called Brady, that if someone's a dishonest person, that the DA will not sponsor that person?
Same objection.
I'm not aware.
It's been asked and answered. The
Okay.
objection is sustained.
And let's take a look at Exhibit 26. That's Barry
Yes, sir.
All right. Barry you did not fire him. You chose to wait the outcome of the criminal case, correct?
Yes, sir. That was one of the domestics we talked about earlier.
So this was after Cerda, correct?
Objection of relevance. This testimony's brought forth the fact this is a totally unrelated matter, a domestic violence matter, not a DWI-related case.
Well, we think we can show relevance because in his meeting, he stated he could not wait to see what the outcome in the criminal case was. And here, he waited to see what the outcome of a criminal case was.
Objection's overruled.
All right. So in Barry he was accused of a felony of continuous family violence, correct?
Yes, sir.
And that's a very serious offense, correct?
Absolutely.
And if it's true, you would fire the person, correct?
Yes, sir.
But instead of firing Barry you wanted to see what happened in the criminal case, correct?
Well, a lot of times with DWIs, we get he said, she said.
Sir, I'm not asking about a DWI. I'm asking about this case.
A lot of times with domestic abuse, it's he said, she said. So we are waiting for further evidence. We take them out of the field, but with the new policy, if we see marks, if we have physical evidence, then we terminate them. So this was under our old domestic violence policy.
All right. So regardless, you waited to see what the outcome of the criminal case was, correct?
Yes, sir.
All right. Now, let's take a look at Exhibit 27. That's Daniel Drury.
The city will object to this line of questioning as this was after a different policy. This was after the March 1, 2019 policy.
How do you respond?
Okay. The date of the incident was December 28th, 2019. You would agree?
Well, we have an objection here, and I'm asking you to respond to the objection. The objection is that the Drury incident, this suspension was after the new policy was issued.
Okay.
And the objection is it's irrelevant. How would you respond?
Okay. The city objected to our attempt to introduce Exhibit 2, and I believe that it was sustained. However, our point is that Exhibit 2 is a harsher level of punishment, that the minimum would be raised from 60 days to I'm sorry. $90 days. So this incident happened under the new policy Exhibit 2, but it still did not result in termination. And therefore, we believe that it's relevant in that regard.
I understand. You can argue in your brief what you want to, but for the sake of this evidentiary hearing, I'll sustain the objection.
All right. So are we not going to be permitted to inquire about any punishment where someone was not fired after the new 2019 policy was implemented?
For the sake of this case, the policy under which the appellant was disciplined applies and not the later policy. So it's irrelevant. You can go into it. I'll entertain any objections. I'm not going to stop you from putting on your case.
Well,
We would also urge, besides relevancy, it's much like what is barred under Texas Rules of Evidence, a subsequent remedial measure when an entity takes actions to improve things. Those matters are not relevant to the prior incidents or accidents or disciplines and would be barred.
well, this is not a remedial measure. It's merely an amendment of prior policy. The only difference between Exhibit 1 and Exhibit 2 is that the minimum is raised from 60 days to 90 days, and it still addresses the same issue of DWI, and the policy is still the same, that there's a settlement agreement and you can agree to a settlement without being terminated. So the only difference is the minimum punishment is increased from 60 to 90 days. So what he's portrayed to this hearing examiner is that there's a culture of tolerance that was sought to be ended when December 2014 was implemented, and the subsequent punishments after 2019 shows that the tolerance of DWI still continued, because even though they increased the minimum from 60 to 90, the offense of DWI still didn't result in automatic termination.
Yes, sir. I understand your argument. But the objection is that post-discipline policy changes don't become retroactive to take into consideration previous cases. So I am sustaining the objection.
All right. When you read the police report regarding firefighter Cerda, you would agree that the information in the police report clearly indicated that Albert Cerda was disoriented, correct?
Yes.
And he explained to you his medical condition is sleep deprivation, correct?
Yes.
And people who vouched for him mentioned that he had issues with his sleep, correct?
I'd have to go back and look at the letters.
Okay. And you would agree that he was not working at his normal fire station, correct?
Yes.
And he explained to you that he had issues with sleep apnea, correct?
Yes.
And he attempted to explain to you that when he moved from his normal fire station to the new fire station, that he didn't have his sleep apnea apparatus with him, correct?
Correct.
And so the cumulative evidence shows that he was disoriented because of sleep deprivation, the medication that he was on, and also his alcohol consumption, correct?
Objection calls for speculation as to the medical aspects. The chief is not a medical doctor, and there's been no medical documentation of any medical condition besides the alcohol intoxication introduced in this case.
Sustained.
All right, so let me follow up with that, Chief, is that your counsel points out that you're not a doctor and don't know about medical conditions. You do agree that Albert Cerda tried to explain to you his physical condition when he met with you, correct?
Yes,
And you do agree that part of his presentation was his medical condition and his lack of sleep, correct?
during our meeting, you mean?
Yes.
Yes,
And afterwards, you didn't consult with anyone to determine whether what he was telling you could lead to him being so disoriented that he unintentionally engaged in his conduct.
no,
So you would agree that based upon everything that you've just said, there's no way of knowing whether when he drove, he unintentionally left and was disoriented. You don't know one way or the other, do you?
that'd be speculation on my part on that.
Agreed. So you would agree that to evade, you have to have the intent to evade, correct? Under the criminal laws.
Objection calls for a legal conclusion.
Sustained.
We pass the witness.
Redirect.
Just give me 1 second, please. We go off the record briefly?
Say again.
Could we go off the record briefly? Just for a
Yes,
minute?
yes. Off the record.
Yeah, could we take, are you saying going forward, just continuing? Yeah, could we take another potty break? No, I'm good, as long as I gotta be here. Could we take another restroom break, though? Thank you, sir.
Off the record, while we're off the record, it's approaching lunchtime. Do you want to finish up the testimony of the chief and then can talk about a lunch break?
We can do that.
Okay. Sound good to you, Mr. Cifuentes?
Thank you, sir.
Are we ready to go back on the record?
We are.
All right, I noticed that one of your co-counsels has stepped away. Is that all right?
We can start.
Okay. Okay, we're back on the record.
Chief, you were given Union Exhibit 68, the notes from the meeting. I think that was, it's that singles.
Oh, I'm sorry.
Can you look at the page? It's 0046 on the bottom. I think it's the second page.
Yes, sir.
About midway through, there's a H and then a C, kind of a lengthy paragraph about the middle.
Yes, sir.
There's a sentence that starts with "he knows." Can you read that for us?
Is it the H?
I'm sorry, it's after there's a H and then there's a C. The C after that, it says the blood work came back 2 weeks ago. This is C, I guess, for Mr. Cerda speaking. And I'm about midway. It's a large paragraph.
Okay.
Just
The blood work came back?
Yeah.
Okay.
Yes, and further down, there's a sentence that starts with "he knows." Do you see that? It's after "happened," the word "happened."
Yes.
Now, is this, I know this is not a word-for-word account of the meeting, but is this where Mr. Cerda is speaking in the meeting?
Yes.
Okay. Can you read that sentence starting with "he knows"?
He knows that the alcohol is a major contributing factor to this thing, and he fully accepts responsibility for making the decision to drive knowing that he drank that day. The worst thing about this has been having to explain this to his daughters
Okay, thank
as to
you.
why I got arrested.
And as far as the major contributing factor, he did not say it was sleep apnea.
No, sir.
He did not bring you any medical documents to that meeting, did he?
No,
About
sir.
sleep- Okay, about sleep apnea.
No, sir.
Now, you asked questions about criminal matters that may pertain to actions taken by firefighters.
Yes, sir.
Is the fire department's investigation of discipline separate and independent of the criminal matter?
It can be, but again, usually you try to rely on both of them, but sometimes our investigation is going to move forward and waiting on the criminal investigation part of it.
And in Mr. Cerda's case, did you have your own documentation obtained from Selma Police Department to make a
Yes, sir.
decision?
We had Selma's report, the emergency room documentation and the video.
You were shown exhibits 61 through 66. These were the letters from colleagues and friends of Mr. Cerda. Do you recall
Yes,
those
sir.
letters? And those were given to you during this meeting?
Yes, sir.
Do any of those discuss the facts of that evening, the facts or circumstances surrounding his arrest that evening during the DWI?
No, sir, they do not.
Now, you were asked about other indefinite suspensions you've taken under the 2014 policy. Do you recall those questions?
Yes, sir.
And those were not documents given to you by, there were no documents shown to you today about those disciplines, correct?
No, sir.
Now, even though those actions may be on appeal, the last step you took was an indefinite suspension under that 2014 DWI policy.
That's correct.
And are those the Samano and Castillo cases?
Yes, sir. Samano and Castillo.
So even though the ones referenced today did not end in indefinite suspensions, there have been indefinite suspensions under this policy.
Yes, sir.
You mentioned earlier a culture when you arrived and your attempts to improve the culture, make improvements overall. That's one of the goals you have as the fire chief.
Yes, sir.
Was the policy you implemented on December 9, 2014, one of those steps you took to correct and improve the culture?
Yes, sir. I mean, and we went as far as to bring SAPD's DWI van out to family night one night and let people put the goggles on so they could, see what it's like to be intoxicated. So we try to do as many things as we possibly could during that time.
And I know you have a lot of employees. It was that an effort to turn the ship, so to speak, in the right direction?
Yes, sir.
You were asked questions about Exhibit 13, firefighter Damian signs.
Yes, sir.
Those actions, by looking at the facts referenced here, those actions took place before implementation of the December 9, 2014 policy, correct?
That's correct.
And your December 9, 2014 policy was effective immediately from December 9, 2014 going forward?
Yes, sir.
It wasn't going to try to discipline someone for acts that occurred prior to that date?
No, we weren't going to try to piggyback this policy on something that happened prior to the policy being distributed.
And could the same thing be said about Engineer Wolf, which is shown in Exhibit 14, and it looks like his actions occurred August 8 of 14.
Yes, sir.
In summary, as far as the actions of the firefighters or engineers that took place after this 2014 policy you implemented, did all of those DWIs, did the actions of those firefighters or engineers, did their actions change once they encountered law enforcement?
Yes.
And with the events that unfolded with Mr. Cerda's arrest and events surrounding the arrest, did his actions change in a positive way once he encountered the police department of Selma, Texas?
No.
Pass the witness.
Chief, can you
Recross now?
can you look at Exhibit 30 in the Union Book?
Yes, sir.
That concerns Lieutenant Brandon Griffin, correct?
I'm sorry, who?
Lieutenant Brandon Griffin, correct?
Yes.
And he committed the offense of DWI prior to your implementing the second policy on March 1st, 2019, because his arrest happened on January 30th, 2019. You agree?
Yes.
So he was disciplined under the same policy as firefighter Cerda, correct?
Yes.
And you alleged in the narrative on Cerda 150, you alleged in the narrative that the Bexar County Sheriff's Office observed him driving his vehicle in the wrong direction of traffic, correct?
Yes.
And driving in the wrong direction of traffic would be a circumstance surrounding his arrest, correct?
Yes.
And driving in the wrong direction of traffic creates the risk of a head-on collision. Would you agree, correct?
Absolutely.
And it endangers the motoring public. Would you agree?
Yes, sir.
You also allege that he disregarded a traffic sign, correct?
Yes, sir.
And when you run a traffic sign, that also creates a risk of collision, correct?
Yes, sir.
And it endangers the motoring public and other officers and emergency responders, correct?
Correct.
And you also allege that he made an unsafe lane change, correct?
Yes.
And that's also, those three things are factors surrounding the circumstance of his arrest, correct?
Yes, sir.
And you also allege that he had a blood alcohol concentration of 0.158. That's almost twice the legal level, correct?
Correct.
And so under our state laws, as you know them, that would be a Class A misdemeanor, extreme intoxication, correct?
Yes.
And he was a newly promoted lieutenant, was he not?
Yes.
And as a newly promoted lieutenant, he was a probationary lieutenant, correct?
Yes.
And as a probationary lieutenant, you had the ability to demote him with or without cause, correct?
Yes.
So let's talk about what you did with Lieutenant Griffin. You did not suspend him, did you? I mean, you did not fire him. You gave him an agreed suspension, correct?
Yes.
And you reduced his indefinite suspension to a 75-day suspension. Would you agree?
Yes.
And you've also indicated that you hold higher ranking firefighters to a higher standard, correct?
Yes.
So the wrong way driving, the disregard for the traffic sign, the unsafe lane change, and the extreme intoxication, and the fact that he's a lieutenant, those 5 factors you took into account to increase his punishment by only 15 days, correct?
Yes.
And when it came to the issue of his recent promotion, you did not demote him over this incident. Would you agree?
Yes. Yes, I did not demote him.
We would offer into evidence all the exhibits that the chief has been testifying to. I believe it's 1 through 30, and also 61, and also the letters of recommendations through 66, I think.
And we lodged objections at the time they were offered and discussed. And I believe Mr. Hearing Examiner had ruled that the subsequent policies or subsequent incidents after the 2019 policy did not apply and would not be considered or admitted.
That's correct. They were subsequent, that's a subsequent policy. It's not retroactive. And as I believe it was number 2, the new policy, March 1st, 2019, I had stated then that I would disregard the policy, although I allowed some testimony on the policy that I disregarded.
So we want to make clear that we're offering exhibits 1, exhibits 3 through 30, and 61 through 66.
And some of those are in those subsequent years after the new policy.
Which of these, if you could help me out here, I have, 68 exhibits here. Tell me specifically which ones you are objecting to, if you would, please. I have number 2 is objected to. The union is withdrawn its request to submit exhibit number 2.
Yes, and then
And of those exhibits, 3 through 30, which specifically are you addressing?
we object to the introduction of 26, 27, 28. And then also 30.
And what's the basis of your objection?
I'm sorry, 30 is under the applicable policy. We do not object to 30.
Okay, in terms of 26, I believe the hearing examiner ruled that it was relevant and admissible, even though it did not relate to the DWI policy. It related to the fact that he was indicted, and the chief chose to defer taking action to await the outcome of the criminal case. So it's my understanding the hearing examiner ruled that 26 was relevant and admissible for that purpose. And also, 28, it's my understanding, was ruled admissible because it related to alcohol-related misconduct that didn't result in termination.
And I don't think there was a ruling, as I recall. 28 was not a DWI, 26 was family violence. We objected to both. Family allegations of family violence.
It's my recollection that the hearing examiner only made a ruling about inadmissibility with respect to 27, and that everything else was deemed admissible and relevant.
You know, as with so many of things, these things, they can come in as argument, and I can disregard them. To cut to the chase, I'm going to let these in, and I will go through, and those that I deem are irrelevant, I'll disregard. That'll cut to the chase, because as we're saying, we could sit here all day and debate the veracity and the arbitrability of the application. So I'm going to allow them to come in on that basis, and if they're irrelevant, you can argue it in your brief, and I'll do it then.
And then as far as those last letters, 61 through 66, we renew our objection that they are hearsay if they're seeking to prove the truth of the matter asserted in them. So we renew our objection to 61 through 66.
And per my usual practice, excuse me, we all know these guys work in the same house. They're friends, and they're expressing their like, even though they may have no applicability to the actual violation. I allow them in for what they're worth as an expression of friendship. So I'm allowing them in for what they're worth.
And I would like to talk about Exhibit 57.
And this was not the subject of his cross-exam. 57 had, so he's on recross. It wasn't addressed in his his initial cross-exam. Therefore, it's beyond the scope of cross-examination. It's further irrelevant to this case, has nothing to do with discipline of Cerda, and he shouldn't be allowed to go into this now on recross since it wasn't even addressed on his first attempt.
So
Bring it out.
the argument beyond the scope of cross is a evidentiary rule, and the rules of evidence don't apply to arbitration. And
That's
so
incorrect.
That's not a basis for going for objecting. So that's not a basis to object. And it's relevant because we believe that there's proof of criminal misconduct, and the chief allowed someone to retire with a full pension.
Well, I will agree with his argument that the rules of evidence don't apply in arbitration. As far as exceeding the scope of cross and direct, I will normally allow the folks to go beyond the scope. Now, as far as, I haven't heard any discussion about this, there's been no foundation for it. So having heard the union's motion to introduce it without any foundation, I'll sustain the objection at this point.
I'll just ask questions. You recall a firefighter?
And we renew our objection. This is a reference to the newspaper article. Looks like it, in referencing it, it's some domestic violence allegations, has nothing to do with DWI discipline, and again, is irrelevant. It's has no probative value to this case. It merely confuses the issue and misleads the arbitrator potentially. It's unfair prejudice and has no value.
I understand, and that's probably most appropriate to argue in front of a jury that can be distracted by evidence. Arbitrators, as you know, you hire us based on our knowledge of what's relevant and what isn't. I'll allow it in for whatever it's worth. You can argue relevance. Overruled.
You would agree that Michael Sean Burns assaulted another fellow firefighter in Medina County, correct?
Yes, sir.
And you knew that he actually engaged in the conduct, correct?
Yes, sir.
And even though he engaged in the conduct, it was he was allowed to retire with a full pension after attacking his girlfriend, correct?
Yes, sir.
And so you did not terminate him even though he had engaged in domestic violence, correct?
He was another one of those domestic violence cases that we were waiting on further information from the DA.
All right, and you are aware that the circumstances surrounding his domestic violence was that he had been drinking all day, correct?
Yes,
And you understood that he had grabbed a fellow firefighter's neck and faced and smashed her head and face to the point where it hurt, correct?
yes.
Pass the witness.
We have no further questions.
All right, sir. I have one question that it was part of your testimony and it was probably mentioned in passing, but if it was, I missed it. You talked about at a point you were interviewing the appellant, something to the effect, he had not yet seen the video. I don't know if you remember that or not.
Yes, sir.
Can you tell me what video, just for clarification?
Probably the same video that you saw. We saw the dash cam video when he was pulled over.
Great. That clarifies it. Thank you. That's all
Thank
I
you.
have. Your excuse, sir.
Thank you, sir. Safe travels.
Off the record? It is 12:05. Back at 1:30? Did it give you enough time to do lunch yesterday? Yeah. Back at 1:30?
I was just thinking, although it's not going to be exactly. Mr. Caldwell.
He said he may have to step out. for
Yeah.
military. The city ready to continue?
City is ready.
City's ready. Call your next witness, please. Are you ready? Okay. Right. You may call your next
At
witness.
this time, the city rests.
Okay, city rest. Is the union ready to go forward with your direct case? Would you get on the mic, please? The acoustics are not good in this room without the
I
mic.
can't go forward, but there's another matter related to my practice that I need to file a motion and wondering if I might have 10 minutes.
You need 10 minutes now, sir?
Yes.
Okay, we'll go back off the record and we'll see you back in 10 minutes or when you can get back. able to do your filings and things on an iPad?
Oh, yeah. I enjoy hearings because it take a vacation from,
Get away from public.
having to deal with other things. But once in a while, just somebody can't wait.
I understand.
Was arrested and needed some application, so.
Yeah, the pleasures of being a defense attorney.
We're ready, yes.
Okay, are we ready to go back on the record?
Yes, at this time, we wish to present our case in chief by calling Albert Cerda.
All right. Raise your right hand, please. Do you swear or affirm your testimony will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Is your witness?
Albert, can you introduce yourself to the hearing examiner by telling us your age?
Good morning, sir. My name's Albert Cerda. I'm 48 years old.
And can you explain to the hearing examiner a little bit about your background, where you grew up, where you went to school, what type of job history you had?
I grew up here on the south side of San Antonio, the same side of town that I would serve in the fire department. I've been at the same fire station for almost 19 years, right out of rookie school. Graduated from rookie school. Sorry. Went to high school at McCollum High School, same size, south side of San Antonio. After graduation, I enlisted in the Air Force, where I served 4 years at Vandenberg Air Force Base in California. I was a HVAC specialist there, assigned to a civil engineering squadron. After my tour of duty of 4 years, I was honorably discharged, came back home, worked at UTSA for probably about 4.5, 5 years before getting into the fire department in year 2000. So it was August 7th, 2000 approximately when I joined the fire
Okay.
department.
So given that you started the fire department August 7th, 2000, at the time that you received the indefinite suspension, how shy were you of retirement eligibility?
At the time of the indefinite suspension that it was issued, I was a year and 3 months away from 20.
Prior to the indefinite suspension, had you had any issues with discipline?
No, sir.
Had you had any issues with missing work?
No, sir.
So if we were to look at your work history, we wouldn't see instances of you calling in sick on your relief, on the day before your relief days?
No, sir. I have accumulated over 1,200 hours of sick leave, only calling in once in 19 years.
And do you have any issues with being tardy to work?
No, sir.
No discipline whatsoever aside from this instance of discipline, is that correct?
That's correct.
All right. Did you continue your education while you were in the fire department?
Yes, sir. After I promoted to engineer in 2005, I believe, I went back to school. I received an Associate of Science in Mechanical Engineering from Palo Alto College. And a few years later, I attended Texas A&M University, San Antonio. I received a Bachelor of Applied Arts and Science with a focus on Fire and Emergency Services Administration in 2014.
Have you been able to, were you able to apply those educational advances to your work experience with the San Antonio Fire Department?
Yes, sir.
Now, in this particular case, it's my understanding that there was no conviction for DWI?
No conviction, yes, sir.
All right, and it was only for obstruction of a highway?
That's correct.
There was no gun charge?
Dismissed.
All right, and you did have a license permit to carry?
Yes, sir.
And so therefore, it was impossible for there to be a charge for unlawful carrying, correct?
Correct.
Objection to calls for legal conclusion.
If he knows.
Well, if he knows what he was charged with, I'll allow him to answer.
Okay, do you need me to repeat the question or can you answer it?
Can you repeat?
So given that you had a permit to carry, you could not have been charged with unlawful carrying on the night you were arrested, correct?
I'll sustain the objection. That does call for, I misunderstood your question. That calls for a legal conclusion.
Okay. Now, to get the permit, you have to know what the gun laws are, correct?
Yes, sir.
And so given your training to get the permit, you knew that you were allowed to carry the weapon in your car, correct?
Yes, sir.
All right. And as far as the evading charge is concerned, can you tell the hearing examiner whether on this night you were aware of everything that you did from the moment we see on the video where the officer gets behind you, whether you were fully oriented?
I was not fully oriented of all the events from the moment that he pulled in behind me.
All right. Now, let's talk about your health history. Prior to this event, did you have health issues? And if so, when did they begin?
I started having medical issues in 2012 pertaining to sleep apnea disorder. I've had several sleep studies since then, indicative of a severe chronic obstructive disorder where I would cease breathing or stop breathing for several seconds during the night. At least 80 episodes is the highest they recorded.
And what effect did this medical condition have on the quality of your sleep?
Very poor to little good quality sleep. It was, it made me tired most of the day. I couldn't gather my thoughts. Sometimes would forget things, because of the disorder.
All right. And eventually, did you obtain any mechanical appliances to assist in the disorder?
Yes, sir. They prescribed a CPAP machine.
All right. And would you take the CPAP machine to your fire station?
Yes, sir. I would leave it in my locker.
Okay. And so the locker would be at your normally assigned station, is that correct?
At 25s, yes, sir.
Okay.
25.
Would it be 25 or 22? I'm a little bit confused. Help me out.
25 is my home station. It's on New Laredo Highway near Military Drive.
So 25 would be the station you went to from the moment you began working?
Yes, straight out of drill school. I was assigned to Fire Station 25, one of the busiest in the city.
Is it unusual for firefighters to stay at that particular station through their entire career?
It's happened in the past, but it's unusual due to the busy nature of the station. Usually veteran status grants you first pick of more favorable stations that aren't as busy.
And why would 25 not be a favorable station?
Just the busy nature of it. You're up all hours of the night, a different variety of calls. There's a lot of bars around the area, so make a lot of assaults.
So it's a service intensive station?
I'm sorry, I didn't.
It's a service intensive station?
It stays pretty regular busy, yes.
All right. And so 25 is your normal station. On the morning of The day you had this DWI, what station were you working at?
I was detailed to Fire Station 22, which is near Stinson Airfield, to be in charge of the engine over there.
All right, and did you have your CPAP machine with you at the new station?
No, sir, I didn't have it with me.
Okay, and did this have an effect on the quality of the sleep that you had that night before the day of the DWI?
Yes, sir.
And did you explain this to the chief?
I attempted to explain it to him. I did, sir.
Okay, and when you say you attempted, what do you mean by you attempted?
He was kind of dismissive. I attempted to show him my medical paperwork that I had received regarding the prior sleep studies, the medication I was taking. I had him in a manila envelope, and he kind of dismissed it and started talking about, the incident in hand, wanted me to talk just about that.
Okay, so you indicated that you had other medical issues and medications. Was that something that developed after 2012?
After 2012, yes.
Okay, and just go through the chronological history of the medications and what effect medications had on you and what steps you took to get the proper medication.
After my struggles with the sleep apnea and it started affecting my blood pressure. So I would go to my primary care doctor, and he started me on a low dosage blood pressure medication. It was having some kind of a counteraction against another medication I was taking for cholesterol, I believe. So they increased the dosage, and they kind of
Okay, let me stop you. I want to be clear. They increased the dosage of which medication?
on the blood pressure.
Okay, and please continue.
Okay, and I was also given cholesterol medication, and I was taking medication for allergies.
All right. At any point in time, did you begin to experience issues with your heart rhythm?
Yes, sir. 2018, I believe it was October, November of that year, I started experiencing extreme fluctuations in my blood pressure, which affected my pulse rate. At night, my blood pressure would be either extremely high or it would bottom out, be extremely low. And at night I would wake up in sweats where my pillow would just be soaked and I'd be at rest. I feel my pulse and it'd be racing. So it got me worried enough to go see a cardiologist.
Okay. At some point in time before the DWI, were you experiencing symptoms that might appear to be signs of disorientation, such as memory loss, dizziness, and the like?
Yes, sir.
Can you explain that to the hearing examiner?
Well, I would have periods where I could be sitting at the kitchen table, watching TV, and I would start to fall asleep, unaware that I'd be falling asleep, and then I'd wake up an hour, two or more later and realize that I had lost that amount of time and couldn't explain, the nature of it.
All right, and as a result of these side effects, did you attempt to seek an adjustment in your medication combination or dosage with your healthcare provider?
Yes, sir. I had also been seeing a nephrologist for my kidneys.
A nephrologist, is that
I
correct?
believe that's what they call it.
Okay, for your kidneys.
Yes, and I guess he got upset with me because he felt that my blood pressure medications were being mishandled by all these other doctors that I had been seeing. So he wanted to be the only one to manage those issues because they directly affected, what he was overseeing with my care.
And tell me what time frame this would be roughly.
This was towards the end of November, December, somewhere in that area.
Of what year?
of 2018.
So this was months before the February 2019 DWI?
Yes,
Okay. And so when you saw your nephrologist, kidney doctor, did he change the combination of medications?
he did.
And when he changed the combination of medications, did some of your issues with disorientation remain, or did they disappear? Tell us what happened.
No, they improved.
Okay. And how much did they improve?
It was drastic. I mean, it was like night and day. I actually was feeling hopeful that I had finally crossed that bridge and was on the other side to better recovery.
All right. And when you were having problems with the medication before the DWI in the year 2018, did you ever combine alcohol with your while taking your medication?
You're talking about,
In 2018 and previous, when you were having issues with the medication, did you ever combine alcohol with your medication?
oh, combination? No.
Okay. And when February 2019 came around, can you tell the arbitrator whether you believed you had overcome the adverse effects of medication?
Yes, I felt I had finally reached a point in my life where my medical condition was being properly managed with the medication assigned to me.
Now, you've admitted responsibility for drinking. You're not denying that, correct?
No, I'm not denying it, no, sir.
And do you believe that, tell the arbitrator whether based upon the medication you were taking and the alcohol, did that have a combined effect on your awareness of what happened?
Yes, sir, I believe the combination of the medication, the alcohol, had a effect that I just didn't foresee, and I couldn't anticipate it. I didn't see it coming. It kind of hit me all at once, and it was just devastating when it happened.
All right, and had there ever been any prior incidents in your life where you had consumed alcohol to excess before this DWI?
No, sir.
So this incident on the day that you were arrested was an unforeseen incident on your part?
That's correct.
All right. And so did you attempt to explain this information to the chief when you met with him?
Yes, sir, I did.
And were you permitted to explain the full extent of these issues?
No, I wasn't.
And explain to the hearing examiner, we're not permitted to explain the full extent of these issues to the chief.
Well, after his request for he calls it a Reader's Digest version, of myself, I got into, my education, my background, where I'd worked previously, where I currently was stationed. And then he moved over to the events of that night, and he wanted me to explain what happened. So I started getting into bringing out pictures that I had taken of the area in question, because up to that point, I still hadn't seen any videos, so I didn't know if he had any kind of idea of the area that I was talking about. So I brought out the pictures, I brought out a map, and I proceeded to show him on the map, where I was parked, where I drove, why I went into this driveway, where the stoplights are, what the speed limit is. And he said he didn't need to see any of that because he had just viewed the video prior to our meeting.
And you agree that you never should have, the first time Officer Rodriguez was behind you and was tapping on your door, you never should have moved forward at that point in time. Would you agree with that?
I agree with that. That's correct.
And can you explain to the hearing examiner why, knowing today you should not have done that, why that happened?
It was never my intention to evade anyone, much less a police officer. We work with police officers daily, every shift. We interact with them. We have good relationships with them. We're very cordial. I would never want to put myself or an officer in a dangerous situation. So yeah, that would have been completely out of character to do that.
All right, and was that the result of you being disoriented?
Right. I mean, to this day, it kind of baffles me that I don't have a clear picture of certain parts of what happened. And I had hoped that viewing the video, would kind of fill in the blanks. But it really hasn't helped. We just got the video a couple of days ago. And it was just like watching a movie of someone else.
All right, so is it your testimony that you agree that you should have remained stopped and you never should have moved from the first time the officer got behind you?
I agree. I should have stayed stopped. Yes, sir.
And so everything that you did thereafter, you should not have done, correct?
Correct.
Is it also your testimony that because of your disorientation, you were unaware of what the officer was wanting you to do?
That's correct.
Can you tell the hearing examiner whether there is an issue with you using or abusing alcohol as a history or since this time?
No, sir. I don't drink alcohol since that night. I completely kept it out of my life. I realized it played a major part in what happened to me that evening. And if I can do anything in my power to remove that from the equation, I haven't had anything to drink in over 2 years.
All right. And if you are reinstated, would you encourage other firefighters to abstain from alcohol and educate them about the dangers of consuming alcohol and your medications that you take?
I would use myself as an example, and I would gladly put myself out there. I would let them know everything that it's done, both physically, mentally, emotionally, how devastating it is for your family members, not just yourself. You end up letting a lot of people down.
And did you go to various battalion chiefs requesting a letter of reference for your meeting with the chief?
I got a letter of reference from my battalion chief in District 2, and I've known him for several years, and he said he'd agreed to write me a character reference letter and even volunteered to come in and testify in person if need be.
All right. And did he have any hesitation vouching for your good character?
No, sir.
And was he aware of the issues you were having with sleep apnea?
Yes, sir. Everyone at the fire station would hear me snore, and they said it was pretty loud. Sometimes would stop in and check on me to make sure I was still breathing in the middle of the night and rip me about it the next morning.
And so he was aware of what effect your sleep deprivation had on your physical well-being?
Yes, sir.
We pass the witness.
Cross-examination?
Mr. Cerda, you were asked about your not being convicted of DWI. Do you remember that question from your counsel?
Yes, sir.
You did enter into a plea agreement, correct? To avoid conviction of a DWI?
Yes, I was given deferred adjudication for the obstruction, and I think the other 2 charges were dismissed.
And when you enter into the plea agreement, you signed a sworn statement stating that you did acknowledge that you were operating a motor vehicle while intoxicated due to the introduction of alcohol into my body, correct?
We object to discussion of the plea agreement, which is post-discharge. And as the hearing examiner has previously ruled, he's admitted that his blood alcohol was 0.13, so it wouldn't have any relevance or bearing on the chief's decision.
It does have relevance to his questioning to follow up and clarify. He opened it up into what happened after the DWI charge and asked questions about his not being convicted of DWI, and I'm entitled to go into circumstances about the non-conviction of a DWI.
That's right, sir. You opened the door. The objection's overruled.
Now, in that judicial confession and sworn statement that you signed, you did not state anything about sleep apnea or some other factor causing the DWI, right?
I don't believe I was asked anything about that, sir.
And you certainly didn't write it in that document provided to the court that you represented. It was
No.
alcohol.
I've never been part of a judicial proceeding. I was depending on my attorney to kind of guide me through it.
In the meeting with Chief Hood, you took responsibility saying that you knew alcohol was a major contributing factor to this event, and you fully accept responsibility, right?
That's what I stated to the chief, yes, sir.
Okay, you didn't state that it was due to this medical condition we've heard about today.
No, he kind of stopped me when I started going into the information about my medical history.
You were asked questions about carrying weapons in a car. I know you're not a lawyer, that's why I objected to speculation about various laws, but you do understand if you're driving while intoxicated, it's a different situation if you're not intoxicated when carrying a weapon.
Objection calls for an interpretation of the difference between UCW when you're not a permit holder and when you are, and given the ruling of the hearing examiner on city's objection, this is not a permissible area of inquiry.
And I think I'm allowed to.
This is the very same thing you objected to earlier, that he was trying to raise, and I sustained the objection, I sustained the objection that he couldn't make a legal finding on that. And I think you're asking for the same thing now.
And I think he rephrased it to his understanding, which if I could go into that, just his
So
understanding.
you're asking him now what he understands. You're not asking him for a conclusion of law?
Yes.
If he knows the answer, I'll allow him to answer.
Did you have a permit to carry a weapon in your car?
I did have a license to carry, yes, sir.
Okay. Your understanding, did you have to have training to get that license to carry?
Yes, sir. I believe it was an 8-hour course.
Did they explain it was not legal if you were intoxicated to carry the weapon?
They explain different scenarios and they go over legal aspects on carrying at courthouses and not taking them into, public schools and things of that nature. But they didn't really get too technical as to like driving while intoxicated or anything like that.
So your answer is you don't know if they cover that topic?
I don't know off the top of my head, no.
Okay. As I understand it, you're accepting responsibility for the events that evening?
You're asking me if yes.
I mean, when you met with the chief, you said you accepted responsibility?
I met with the chief, that's what I told him, yes.
And today I'm hearing that, doesn't quite sound that way. I'm hearing that you had health issues, that you're blaming for disorientation, that you weren't getting good sleep because of locations of between station 22 and 25. Is that what you're trying to convey today?
That's what I tried to convey to the chief when I first met with him at our meeting, sir.
And you never reported in the timeframe you're stating from 2012 to the event of February of 19, that you never reported these medical issues, did you?
Reported to who?
You didn't report to anyone in SAFD of these medical issues that affected your job in any way, did you?
The wellness center through the SAFD is who initially had me seek out help for my sleep apnea.
And you never, these medical conditions you've described never prevented you from being at work in that time period, correct?
Being at work, what do you mean?
You said you never missed a day of work in your time with SAFD?
No,
And that included this time period from 2012 to the night of the event?
that's correct, 19 years, called in sick once.
And you're not blaming your location where you're working around the time of the February 2019 incident for you're not blaming that location on the fact that you drove while intoxicated.
I don't understand the question.
Well, you talked about being assigned to station 25 and station 22. Do you recall that testimony?
I was assigned to Fire Station 25.
And you were then at station 22 around the time of the event?
On the 23rd of February, I worked a 24-hour shift at Station 22.
You're not blaming the fact you worked at that location, that shift on the, you're not saying that caused you to drive while intoxicated, are you?
What caused me to drive, I don't understand, being at that station, like that particular station made me want to go and drive and talk. Is that what you're asking me? I don't know.
Are you saying that caused you to drive while intoxicated, the fact you were at that station?
No, I'm not stating that.
Now, you just testified at the very end that you have not used alcohol for the last 2 years. Is that right? Did I hear that correctly?
Yes, over 2 years.
Do you recall the revocation of your probation in the last 2 years for alcohol use?
I'm going to object to any after acquired evidence. It's not, was considered by the chief.
I can't hear you.
Object to any after acquired evidence, and I think it mischaracterizes what actually happened in the court proceedings. There was no adjudication that alcohol was used. There's only an issue of whether or not he took the breath test.
And he opened the door again and representing to the arbitrator that there was no alcohol use in the last 2 years. I'd just like to follow up with a question on
Well,
that.
there's no finding that in what you're referencing that there was any alcohol use. It's only about whether or not he
There's an exhibit on point that would refute that testimony just given, and it goes to the credibility of the witness.
I hear your objection, sir. I'm going to overrule the objection. You can come back and address it on redirect. He did open the door by saying he hadn't had a drink in over 2 years. If the city has something to dispute that testimony, I'm interested in seeing that.
Can you refer to Exhibit 10 of the City of San Antonio exhibit, sir? And that is titled The Violation Report.
Yes, I'm there.
Styled State of Texas for Alberto Vasquez Cerda. Do you see that?
I see that, yes, sir.
Do you see where it states the following violations have occurred? Condition 2, tested positive for alcohol on 10/16/20. Do you see that?
Where it says on 10/16/20, submit a urinalysis, that is what you're talking about?
we would object to this further on, we object further on the grounds that this is hearsay within hearsay. This is a violation report. It doesn't include the urinalysis test result, and there's no supporting documentation of what the test result was. Furthermore, there was no hearing on the issue of whether or not it was positive, and no finding by a court that it was positive. So it's hearsay within hearsay, and not only that, but in the document, Mr. Cerda denied having used alcohol. So it's not probative of anything.
Overruled. You may continue.
Mr. Cerda, did your probation get revoked at this time?
No,
Did you submit a urinalysis that tested positive for alcohol on October 16, 2020?
I got a report back from the lab that it had tested with a trace. And I asked my probation officer what I could do to appeal that, because there was no possible way that that could be true, because like I said, I hadn't had one drop of any type of alcohol in over 2 years. I don't know how long I've been at that point, but
Were there other occasions when you failed to submit tests to the device where you skipped the testing?
I would object to the relevancy of submitting tests. It's different from whether there was consumption of alcohol.
Overruled.
Do you remember that when you were working at UT Health Science Center and you did not submit to the required test for alcohol use?
You're talking about the mobile start smart monitor device?
I'm actually referring to Exhibit A, the violation report. Yes, the Smart Start mobile device.
What page is that, sir?
That's City Exhibit 8. It's 464, COSA 464.
Okay, I'm there.
Do you recall that happening where there was this violation report of failing to comply with the testing requirements?
Part of the requirements given by the judge, Christian in this case, was that there'd be 4 test windows per day, one at 5 in the morning, 5 to 7, one from 10 a.m. to noon, another one from 5 to 7 in the evening, and then the last one of the day was from 10 at night to 12 at midnight. So 4 times a day for a year, you bring out the device, you blow in it within that 2-hour time period, and it sends it off, I guess, wirelessly or something to some recorder somewhere. And then that gets sent to the PO to review. In the process of when I first started using that machine in, I think it was August, right away, he had it issued. There was a process, kind of a lapse in a process. There was a lapse in the time windows, like they weren't set the way the judge wanted them to be set. So I had to go back to the place and have them reprogram it. But in the process, it marked me as missing the time window. And the probation officer said if I ever missed one, whether if I was at work and was, on a roof or working on equipment and I couldn't get to the unit in that 2-hour window, just to blow it in immediately after, and it would be recorded. So it's my understanding that if you miss a 2-hour window, it does send a signal that it was missed as a breathing sample. But if you give it like 5 or 10 minutes later, it still records it for that day. So there's a record that you did blow, you just missed your window.
You admit to missing that window?
Yeah, I mean, 4 times a day for a year, there was times where I'd be driving home from work and couldn't pull over, or we'd be eating at a restaurant and, I'd have to go to the parking lot and grab it out of my backpack. You always had to have it with you. Or sometimes I wouldn't wake up in time, 5 in the morning to 7 in the morning, after going to bed, getting home from work. At 2 a.m. it was kind of difficult at first, but I adjusted, and I never had a negative report from either of my probationary officers that I've had.
Do you recall being ordered for that October 16th violation, ordered by Judge Christian that you were to report in response to the motion of the probation violation and to revoke the probation?
Yeah, from what I understood from my PO, that's his common practice is he wants you to go and appear in front of him and explain what happened. If you felt there was a mistake, he wants an explanation and he hear you out and he make a ruling accordingly.
We moved for admission of exhibits 8, 10, and 11.
We would object that they're after acquired evidence, not relevant to any issue in this case.
And I think they obviously were after the decision was made, but it goes to the credibility of this witness.
And the objections overruled, it's admitted. Those two, 8 and 9 are admitted.
And it was 8, 10, and 11 for the record.
Say again, I'm sorry.
It was exhibits 8, 10, and 11 of the city.
8, 10, and 11, thank you.
We have no further questions.
Redirect?
Yes. Give me a moment real quick. Do you recall in the meeting with the chief that he referred to you as a good dude?
Yes.
What do you recall about him speaking about your history?
He said that basically you look like a firefighter who's had an unblemished career to that point. No disciplinary issues whatsoever.
And did he explain to you that he had no choice but to fire you?
He went into it a little bit, not in too much detail.
And did he seem that the reason that he said that he had no choice but to fire you is what other firefighters did, not necessarily what you did?
Objection leading and hearsay.
It's critical testimony. There's been a substantial amount of leading and I've allowed it, but this critical testimony, I'll sustain the objection.
It's sustained or?
I sustained his objection to
Okay.
leading. You may rephrase your question,
Okay.
please.
Do you recall whether the chief said that his choice to fire you was owing to your conduct or whether it was owing to other firefighters' conduct, if you recall?
From his statement from the meeting, he said that, you seem like an all right, good dude, father figure, good dad. He goes, but I just don't see how I'm gonna be able to keep you. I got all these other issues with firefighters, acting out and doing some dastardly deeds or something to that effect is what he said after the arrest. And he kind of alluded to, how am I supposed to defend this to the media or explain it to the citizens? And he also mentioned something about he also has a new boss to answer to.
All right. Did he ever say that your conduct was dastardly to you?
No, sir.
All right. So he never said that it was your conduct that gave him no choice?
No, sir. I've been waiting to hear that the reasoning for that up until this day.
All right. So based upon your answer, would you agree that he never explained the circumstances surrounding your arrest that were egregious, that warranted termination?
I would agree. He never explained that, no.
All right. Pass the witness.
You understand, Mr. Cerda, in that meeting, it's your opportunity to explain to the chief, right? It's not the other way around.
No, exactly. I was waiting for that meeting up until that day, and that's why I had to rush to go take the pictures that I took at the last minute to explain my side of the story and kind of give them a better picture, explain my medical history, my issues, the fact that I had no disciplinary issues in over 18 and a half, 19 years, kind of give him all the knowledge that he would need to make a determination. And I don't feel I was afforded that.
And you heard his testimony today about all the evidence he had about the facts related to your case. You were here when you heard him testify, right?
I heard him testify about what he took into account.
Right. And you've seen the video in this case where we're able to rewind from the moment it started. You saw that where we played it back, went forward with the video of your incident.
Yes.
And you've talked about your prior years with the SAFD. The chief couldn't rewind it and go back to the events before that night. He had to take into account the events that transpired when you drove while intoxicated. That was what he had to consider as part of his discipline. You understand that?
Are you asking me, what are you asking me? I'm sorry, I got lost in half of what you were saying.
He had to consider what happened that evening. Your actions, that was what he had to consider. You understand that?
Yes.
Okay. Pass the witness.
Redirect?
Yes. On January 30th, 2019, we know that Lieutenant Griffin was arrested for DWI, and you were arrested for DWI 25 days later. And Lieutenant Griffin was driving the wrong direction of traffic, disregarded a traffic sign, and made an unsafe lane change, and his blood alcohol level was close to twice the legal limit. Yet he was not fired. Do you find the circumstances surrounding his arrest to be as egregious or more egregious than the circumstances surrounding your arrest?
Going to object based on speculation. He's not aware of all the facts of that case. Didn't sit in the position of policymaker or implementation of DWI policy for the city of San Antonio Fire Department.
I'll sustain the objection. It's a good subject for argument for the arbitrator to make a decision on that. May continue.
All right, would you agree that at no point in the video that we see of you are you driving in the wrong direction of traffic?
That's correct.
And so you didn't create the risk of a head-on collision by driving the wrong way, correct?
That's correct.
All right. And your blood alcohol concentration was lower than 0.158, correct?
That's correct.
And you recall the firefighter that drove on the highway without a tire and just on his rim?
Yes, sir.
And there was nothing like that in your case, was there?
Objection. Again,
No,
this is
sir.
speculation on the other case. He has no knowledge.
If he has any direct knowledge of that case, I'll allow him to testify. Otherwise, it's hearsay. So I'll sustain the objection unless he has direct knowledge.
Pass witness.
Mr. Cerda, you sat here during my questioning yesterday and said you could remember the route you took driving on Interstate 35, your speed limit. So we don't know if you were endangering other people when you were unconscious or couldn't remember. You could have been driving the wrong way. We don't know that, do we? You can't remember.
I stated I didn't remember certain parts of that evening. I believe that was my testimony yesterday.
So we don't know what happened in those times you didn't remember.
When we saw the video yesterday,
We saw a video of your encounter with the police. We don't know what happened before you got there, do we? The way you drove.
I gave testimony to everything as far as my knowledge of that evening.
And there were many parts you didn't remember.
There were parts that I did remember, sir.
But there was much of your driving you simply don't remember. Do you recall that testimony yesterday?
There was a lot of testimony yesterday.
Do you recall the parts where you said you didn't remember while you were driving?
I'd have to go back and review, but I know that I did say I don't remember certain events of that evening.
Thank you. Nothing further.
Nothing further.
Okay, before I allow you to leave the stand, I have a couple of questions. Can you give me the exact date of hire, sir, that you hired?
August 7, 2000.
Okay, and because I did have a chance to review the video last night on my laptop computer, it was much more clear of what was actually transpiring. Do you have that video with you today? Would you pull up one? Okay. We skipped over a lot of the video yesterday, but I had, because we adjourned early, I had a substantial amount of time to review the video at 1:34:15. Can you pull it up to about that position? please. 1 hour 34, 15 seconds. And it's when the appellant was being put into the ambulance. All right, stop right there. Stop. Okay. Sir, if you know, do you know who the individual is in the blue jacket?
No, sir. I didn't get to see his face. Can you rewind it a
Can
little
you
bit?
back it?
I said no. I can't see his face right now.
And the reason I ask, he's the person who rode to the hospital with you.
Oh, okay.
Watch to the left, you'll see his face. There. You recognize him, sir?
No, sir.
Okay, that's all I have. Thank you. Anything further?
Nothing further.
Nothing further.
All right, sir. You excuse from the witness chair. Thank you.
Thank you, sir.
Is you ready to call your next witness?
We would rest.
Union rests? Okay. We'll go off the record.
Sure.
Okay, we've had a conference off the record. The court reporter estimates the transcript will be ready by May 28. The advocates have agreed to submit briefs by June 25th. And we can make that anytime during June 25th up till midnight. And it's also been discussed that if anything comes up with either the court reporter or the advocates that they need a little extra time, that they will let me know and we'll adjust accordingly. With that, the record's closed.